and any legal claims, action suits in relation to company. This is Ascot.
Correct.
Ascot is JV.
Correct.
Controlled by my subsidiary. I'm Starlight.
Correct.
I have 100% control of Augustus, at least on paper.
Correct.
In reality, controlled by Jagriti.
Correct.
But the requirement of the JV itself is that they need the consent of Augustus and through Augustus of Starlight.
Where is that?
No, when it says control, the court will see. I'll come to that. I'll just read 6.3, 6.4, 6.5.
The quorum board for the adjournment
for any adjournment meeting shall be 1/3 of its total strength. In any fraction contained in 1/3 being rounded off as 1 or 2 directors, which is higher, such quorum shall require the presence of at least one director.
You mean to say that 13 is to be read by 6.3? There is no resolution.
So 6.3, 6.5 also.
Okay.
I'll come straight to 6.5. Neither the board of directors of the company, nor the company, nor anyone on behalf of the company shall take any action in respect of any of the following matters, except on the vote of majority of the directors entitled to vote on resolutions, whether at the meeting or by circular resolution, provided such majority includes the affirmative vote at least of one director nominated.
Okay. Got it. Because it is continuation.
It's continuation. Now the other relevant part of this is on page 137 is the arbitration clause, which says it has to be done.
ICC rules of arbitration in case the parties agreed upon, or one otherwise 3 arbitrators. Such arbitration shall be held in Singapore and shall be in accordance with the decision. Whether this was not brought to the notice of the arbitrator?
Yes, the court will see the arbitral award for a minute, and the court will say it's very interesting what the arbitrator says about this to show collusion and fraud. That's my entire case. That is on the second page
of the award.
Of the award itself. 16.3. As disputes and differences arose between the parties, a letter dated 13/3/2012 was written by Jagriti Trade Services Private Limited to Augustus Avani Land Developers Private Limited for appointment of arbitrator for the resolution of disputes and differences arising out of the joint venture agreement dated so and so. In that letter, it was made clear that the respondent company, that is Neeraj Kumar Pandey, expressed their inability to have the matter arbitrated in Singapore as per ICC rules. The claimant company waived the condition for arbitration stipulated in 16.2 of the joint venture agreement dated 12/7/2007 and would like to have the arbitration before a learned arbitrator under the 96 Act at a place in India. And the claim proposed by name as arbitrator. In the matter, as all efforts to resolve disputes amicably failed, as such, in the said letter, claimant wanted to know the objection, if any, of the respondent to the said proposal. This letter, the court will be pleased to see, in answer to the same, respondent company by its letter dated 17/3/2012. The letter of Jagriti is 13th March 2012.
Correct.
And the response is within 4 days, 17th March 2012, giving the consent. This collusion. Gave the consent to the proposal put forth in the said letter 13/3/2012 sent by the claimant company and wanted to have the arbitration to be held in India in terms of the 96 Act. And this is within 3 months of the Bombay High Court dismissing the petition saying you can't encash your 20 crores. And then the court goes on to record, in fact records.
Court has recorded that whatever the document they have placed.
Just the document, but then there's no finding on the documents. It is only admission on liability.
No, but it is on consent. If the party settled,
precisely, and that we are saying is collusive.
Oh, that is different.
That is what the challenge is.
No, that's why you are not aware. Now you are challenging that this is the collusion,
and that's the reason. It's a question of fraud that has to go to trial. Correct. Right now, we've been arguing whether my objections have to be
so whether that was with the knowledge of you or not.
And admittedly, it was not even not party either to the joint venture or arbitration proceeding or to the award, though it's my money. And the court will see, now when the court notes, the court will be pleased to see what the award says. The court will be pleased to see. I'll just take the court to the actual document because these are extracts and that won't give a complete picture. The court may come straight to page 155 of my response reply itself. Page 155.
Yeah.
I had not applied for bringing FDI through the automatic route. I applied to the government. Government gave me approval on 14 June 2007 as per
Correct.
this letter.
Yeah.
As per this letter, in paragraph 4, I was supposed to bring 10 million in.
Correct.
That's all. There's no other mention of 5 million. On the contrary, on next page, page 6, approval is subject to the following condition.
Yes.
Downstream investment shall be as per press note 9 of 1999. What is para 6? Downstream investment shall be as per press note 9 of 1999.
Issued by
The
the
construction development activities undertaken will be as per the press note 2 of 2005. So, for the money, downstream investment is the 1999 press note.
Yes.
For the nature of construction is going to be the 2005 press
Yes.
note. This is what the approval says. I've attached both the press notes. Press notes of 99 is on page 158. Not a single word on 5 million. That's 158. Not a single word of 5 million out here. On the contrary, 1A says downstream issuances may be made within foreign equity levels permitted for different activities and automatic route. There's no requirement of 5 million.
Yes.
Or the press note 2 of 2005 is on page 160, where A talks about the construction, nature of construction, B talks about the 5 million. A is applicable to me as per the approval letter, not B.
Minimum area of the development. Yeah. So investment would be further subject to that is the 5 10
million. That B is not applicable to me because the press note says investment will be as per 99 road. Nature of construction will be as per 2005 note. Nature of construction is A. Minimum area to be developed on each project will be this.
Okay.
So the approval letter which is given makes only the nature of construction of 2005 press note applicable to me, not the money.
So press note 9 is not applicable.
Press note 2 of 2005
It is applicable.
Is applicable only for nature of construction.
Correct.
That is clause A.
Correct.
Clause B is not applicable.
Yes, clause B with regard to the 10 million for the wholly owned subsidiary
5 million,
of 5
that
million.
is not applicable.
Why?
Because going back to
Press note
page
9.
156.
Press note 9.
Page 156, approval letter. Downstream investment will be as per 99.
Okay.
Construction development activities undertaken by the company as well as downstream entities will be as press note 2. So only the nature of construction activities I go to press note of 2005. For downstream investment, I go as per 99.
Okay. Good.
So there's no statutory requirement. There's no contractual requirement. It's admission made by the rogue director that I have to give 20 crores after having failed to get the checks in cash to the Bombay High Court.
Yes.
It is in this context the court will see what the letter written by Jagriti, which is on page 172, out here itself in the same compilation, to the RBI. This is 3rd September 2010 to the RBI, and on the last page, 175, Augustus has been requested to infuse funds.
We therefore request you to issue appropriate order
to
infuse the US
5 million as per press note 2. When there's no requirement, that 5 million is inapplicable to me by the approval letter itself. They create a bogey. They create a non-fictitious requirement of 5 million. And what does the rogue director say? Rogue director writes to the RBI, which is on page 170. The Neeraj Pandey, who has the same address, writes on page 170 to the RBI that we are complying by giving this 20 crores check. We have made downstream investment in Ascot. Joint venture agreement was executed on so-and-so date. This was made under approval letter of so and so. The approval letter itself is falsifies this. We have issued 2 checks for 20 crores towards that 5 million.
Yes.
And on the basis of this, they go to the Bombay High Court. Bombay High Court dismisses it. On the basis of this, they go to the arbitrator, make admission, and get a collusive award.
Yes.
Now, I'm entitled to prove this during trial. And if I succeed in saying that this is fraudulent, the consequences follow. The consequences follow are in the compilation which I have given. Rigors of Order 21, Rule 58 don't come into play. Because the Supreme Court has said time and again that then there's no question of waiver, estoppel, acquiescence, limitation. The court may just see the compilation. This is the final reference I'll make before I conclude my arguments. The court may be pleased to just see the compilation which I had given. And the court may come straight first to case number 13. I'll just read on the head notes. I won't trouble the court with the judgments. Just the head note of the extracted on case number 13. Yes. Papaya Shastri. It is a well-settled proposition of law that a judgment, decree, or order obtained by paying fraud on the court, tribunal, authority.
That you already referred.
I've already referred to.
Yes.
There is no question. Then it says I can at any stage in appeal, revision, writ, collateral proceedings.
You can
bring it in, and that is the same view taken by Supreme Court in case number 14. The plea, the arbitral award, the nullity can be taken at any stage and also collateral proceeding. Waiver, estoppel. The court may be pleased to see the words what my learned friend had argued. Waiver, estoppel, acquiescence is no bar against the plea, the arbitral award is the nullity. And on the issue of limitation, this honorable court on the case number 27 has taken the view that fraud admits no bar of limitation in the matter, granting adequate relief against it, and the court's power to undo the mischief. Because what I'm seeking is lift the corporate veil and please give the money back to me, yes, caused by fraud or resulting from the same. The further consequence of it being a fraud, and this is incidentally dehors the liberty granted by the Supreme Court. What I was saying yesterday, doctrine of merger is one part. Independent of the liberty granted by the Supreme Court, I can maintain the objections under 151 saying fraud in practice.
If you create the fraud.
That now the court may just see finally the judgments which are the judgment which is case number 19. That because they had said I can't file multiple proceedings, I can't file a suit and an objection. And the view taken on case number 19 is that the plea that arbitral award is void can be raised in execution proceedings. This is on case number 19, Union of India versus Jagatram. A judgment decree can be directly attacked by the procedure prescribed, namely by filing objections thereto or by appealing against the order rejecting the objections. But that does not preclude a collateral attack in the award decree in execution proceedings. The proposition judgment debtor may claim decree to be nullity in execution proceedings and that a decree is void is too well settled. A collateral attack is not barred because the opportunity to raise the same question by directorate was not availed. This well settled principle applicable to civil courts executing decrees. And then I'll just the judgments which are on.
Okay, judgments you already referred.
I referred to 15, 16, 17 are all judgments for the proposition. I won't take court more through that. All for the proposition judgments passed by this court, saying that it is always open for me to bring in the plea of fraud or a judgment being nullity in execution proceedings.
Correct.
So these were the 4 points which were raised by my learned friend. Res judicata, maintainability, Order 21, Rule 58 and 151,
and
Section 430 Companies Act, and the fact there's no fraud. My respectful submission is all 4 points are a matter of trial, cannot be summarily decided by pleadings. Some court has to decide this issue of whether there was fraud or not. This whole, what I've taken the court through today is not the subject matter of the order of the Honorable Division Bench. that is confined on the issue of whether civil court has a jurisdiction.
That you already.
They've not gone into the merits.
Okay.
I'm deeply obliged.
Thank
Now, if I may, the court had directed both parties to bring the written notes of arguments. I brought mine. But in view of the order passed yesterday by this honorable court requiring the receiver to put that, to make a report as to what amount, only
That
indulge.
is there. That is there. Let them file.
Lordship, Mr.
only
Mr. Bose
indulgence.
would also like
No
to
further.
address.
You need it.
Just for
The,
5
the
minutes.
only indulgence would be
ma'am.
that
Just for 5 minutes, my
Reply to reply cannot be.
Written notes of arguments, 1 week time.
Or you want to reply, come on Saturday, Sunday, I will sit here.
1 week time to file.
So that your lordship would kindly grant the receiver a liberty to file the report.
I already passed the yesterday order.
Great.
Within 2 weeks, you file the report. What is the status of the amounts?
Great.
Lordship, may we file our written notes of
Yes,
arguments?
file the written notes of argument.
In a week, Lordship?
Hearing concluded. Parties are directed to file their written notes of argument within how much time? Within
I'm even carrying it right.
1 week,
Uh,
Lordship.
Within 1 week.
one submission. I'm carrying the written notes even today. I can give it over. We may be permitted to file that. I'd just like to see the report before, in case if there's any additional thing, we'll put it only in the written note itself.
No, report only. I ask what is the status of the amount.
No,
Nothing else.
that will also be clear whether that even check was handed over or not. So there are a lot of that, the check.
So that was handed over to Ascot.
So we'd like to see the report, what it says.
That I've taken the instruction. It was handed over to Ascot. That 28 crores amount and the 42 lakhs plus the interest thereafter and the small interest which is lying in the 2 accounts. Those are lying in the State Bank of India, the Calcutta.
So how
branch.
soon you? I have given 2 weeks time.
I'll file it. I've
We'll file it.
already
So
informed.
I am fixing
Very
on that.
well, then we'll follow it in notes in 1
Fine.
week. Within 1 week, we'll follow it in
So
notes.
kindly give a date.
Well, parties are directed to file their written notes of argument. आज क्या तारीख है? 22nd. File on 30th July. 30th July 20. Let the matter appear on 30th July as under the heading to be
Just
mentioned
give me
for
a minute.
filing written notes.
The 30th July would be 1 week.
No, written notes.
Written notes is 1 week, report is 2 weeks.
The court is, the matter being listed on 30th July?
To be mentioned only for filing written notes of argument.
Very well, because I also, I must, to refer to the court, I also must point out that application has been, will be filed today. They've removed, there were some objections. They've been removed, they'll be filing today. So that also probably some date will be coming up for that. That the Augustus application filed by the new directors. So then my submission
And then
is,
they will take the time to file objection and all this, and then,
then
it
that will
remain.
be separate in that case. Or would the court be pleased to pronounce orders on this after hearing those objections?
No,
because-
if they have filed, then all the things is to be taken together. Otherwise,
Very
they
well,
contradict
very
it.
well. No, I'm
So
just
I am
saying-
fixing on 5th of August. File on 5th August. That to be mentioned. In
Uh,
the meantime, you file also reports.
very well. 5th of August.
5th
For-
of August has to be mentioned for filing written notes. Let the matter appear under the heading to be mentioned for filing written notes of argument. Clarified?
Deeply.
Great.
Deeply obliged for the very patient hearing.
Yes, next.
My lord, in item number 1, I am for the decree holder. I want to withdraw, my lord. The matter is settled, my lord. As per my undertaking given on the last occasion, my lord.
In item number 1, I am appearing for
Yes.
the judgment debtor. If I have paid the entire money, the decree stands satisfied. Lordship,
Yes,
kindly-
it is said. It is settled, my lord. Yes.
Record an order.
Lordship kindly records that the decree is satisfied and dispose of this.
What was the total amount?
Your Lordship kindly takes your Lordship's last order 26th of June 2025. That
They
your
have-
Lordship records
Kindly
that
see
the
the
matter
price
has
of
been
same, my lord.
settled between the parties at 80 lakhs. Paragraph 3 of your Lordship's last order.
My undertaking is at paragraph number 4, my lord.
Decree holder has given undertaking that the check is all the check has been encashed.
Yes, my lord. I have instruction, my lord.
It is informed by the learned counsel for the decree holder that the decree holder has received the total settled amount of rupees 80
80
lakhs.
lakhs, my lord.
80 lakhs, and as such, the decree holder is satisfied with the amount paid by the judgment debtor,
Yes, my lord.
and thus he does not want to proceed further. with this execution proceeding. In view of the above, and full stop. As the decree holder has received the total settled amount of rupees 80 lakhs from the judgment debtor, accordingly, EC Com 134 of 2024 is disposed.
Grateful, Lordship.
Grateful.
Will it be your Lordship's pleasure to record that the decree stands satisfied?
क्या बोला ऊपर 80 lakhs ना 80 lakhs क्या बोला proceed with our in view of the above, this court find that the decree has been satisfied
Grateful, Lordship.
by receipt of the amount of rupees total by receipt of the total settlement amount of rupees 80 lakhs.
Grateful, Lordship. Obliged.
Next.
That I appear for the judgment debtor
Yes.
for examination of the judgment.
The award holder.
Yes.
Well, I am ready to proceed.
It may step in.
Examine.
मामले में आप पहली बार मैं तो बोलूंगा बोलिए मैं कसम खाता हूँ
मैं कसम खाता हूँ
जो कुछ भी बयान दूंगा
जो कुछ भी बयान दूंगा
वो सच होगा
वो सच होगा।
मेरे बयान में कुछ झूठ नहीं होगा
मेरे बयान में कुछ भी झूठ नहीं होगा।
ईश्वर मेरी सहायता करेंगे
आदिनाथ भगवान मेरी सहायता करेंगे।
आपका नाम
पंकज जैन।
पंकज
जैन।
जैन पिताजी का नाम
लेथ महावीर चंद जैन।
एक महावीर सिंह जैन
महावीर चंद।
महावीर चंद्र जैन आपकी उम्र
मेरी 52।
क्या करते हैं आप
मैं जॉब करता हूँ।
सर्विस घर का पता बताइए धीरे धीरे सर
427 फर्स्ट सी रोड सरदारपुरा जोधपुर।
धीरे धीरे
427 फर्स्ट सी रोड
फर्स्ट सी रोड
सरदारपुरा
सरदारपुरा
जोधपुर राजस्थान।
राजस्थान
May I start, Malad?
Yes.
Mr. Jain, how are you connected with this judgment data?
आप इन जजमेंट डेटर से कैसे संबंधित है
अच्छी से
जो जजमेंट डेटर है उसके साथ आप कैसे संबंधित है कनेक्टेड कैसे है
मैं पहले एक बार आया था यहाँ पे तो मेरे
ना आप जो है जजमेंट डेप्टर से कैसे कनेक्ट है इनसे आपका क्या
LMG Shipping Private.
रिलेशनशिप क्या है जजमेंट डेप्टर
नहीं कोई रिलेशनशिप नहीं है।
आई डू
He
नॉट
does not understand what is judgment debtor.
No, you cannot talk.
नाम बोले था ना
जस्ट अ मिनट
You can't talk.
LMG शिपिंग प्राइवेट लिमिटेड से आपका क्या कनेक्शन है
मैं उसमें जॉब करता था।
आप जॉब करते हैं
आई यूज्ड टू सर्व देयर आई यूज्ड टू सर्व इन दैट कंपनी
What is your designation
आपका डेजिग्नेशन क्या था वहाँ पर
in the judgment debtor company?
कंपनी में आपका डेजिग्नेशन क्या था
मेरा कुछ नहीं नॉर्मल जॉब था जो मेरा
आप किस पोस्ट पर काम करते थे
मैं सर्विस एडवाइजर के हिसाब से।
आई यूज्ड टू वर्क देयर एज अ सर्विस एडवाइजर पहले समझिए
ठीक
ठीक है
Director বলেছে কি affidavit? Mr. Jain, how many directors are there in the judgment debtor company?
कंपनी में कितना डायरेक्टर्स थे
जस्ट अ मिनट
डायरेक्टर
व्हाट इज हिज नेम व्हाट इज हिज नेम
Pankaj Jain, madam.
पंकज जैन यस
कंपनी में कितने डायरेक्टर थे
दो डायरेक्टर
देयर वर टू डायरेक्टर्स इन दैट सेगमेंट
Can you name them?
आप नाम बता सकते हैं उनका जो डायरेक्टर थे
हाँ एक तो मैं खुद ही था
आई
और
एंड द
और
सेकंड वन
दूसरा मैंने सुना था कोई नवनीत जैन करके है।
एंड द अदर वन इज सम नवनीत जैन एज फॉर आई नो
When have you joined this judgment debtor company as director and when have you resigned?
आप इस जजमेंट डेटर कंपनी में डायरेक्टर की तौर से कब ज्वाइन किए और कब यहाँ से निकले
मैं 31 अक्टूबर को ज्वाइन किया था 31 अक्टूबर 2015 को
31st October 2015
15
I joined the company as a director
लेकिन
बोलिए
ड्रॉप मैंने कर दिया था 17 फरवरी 2016 को
and I out from that company on 17th February 2016.
16
Except this judgment debtor company, are you director in any other companies?
जजमेंट डेटर कंपनी को रिपोर्ट कर
Sister concern.
नहीं
और किसी भी कंपनी में
नहीं।
क्या डायरेक्टर है?
नहीं
नो।
Do you know who are the sister concern or group companies of this judgment debtor company?
जजमेंट डेटर का सिस्टर कंसर्न और कंपनीज कौन सा है आपको पता है?
नहीं
কি বললো? As of today, what are the assets of this judgment debtor company?
आज के तौर पे इस जजमेंट डेटर कंपनी का एसेट क्या है? क्या क्या चीजें हैं इस कंपनी?
इसमें एसेट्स मेरे ख्याल में 90 लाख कुछ रुपए का एसेट्स है।
द कंपनी होल्ड्स एन एसेट ऑफ रुपीज 90 lakhs
90 लाख अप्रोक्स है, कुछ 30-40 हजार के ऊपर हो सकता है, थोड़ा बहुत ऊपर नीचे हो सकता है। 90 लाख 40 हजार 30 हजार कुछ
আগের এফিডেভিটটা কোথায় যেখানে ডিরেক্টর বলেছে কি বললো
approximately 90 lakhs
इसका हाँ सब सेपरेट है।
what are the assets like movable immovable
एसेट्स
Same है मतलब?
तरीके का है, मूवेबल एसेट्स है, इमूवेबल
इसी अलग अलग है ना।
अपन में किसी से हम लोग मांग रहे हैं जैसे
प्रॉपर्टी
हाँ, separate
ऐसा
नहीं
है, क्या है एसेट?
हाँ?
किस तरह का एसेट है?
हाँ वही
कंपनी में
है,
पैसा दिया हुआ है वो है,
अलग अलग टाइप
इसमें कुछ
अलग
नाम
अलग
होंगे
कॉपी
उनके पास।
90 lakhs किस तरह का बैंक कर रहे हैं? ये प्रॉपर्टी है या मनी है, क्या है?
लेकिन कैश में नहीं है, पार्टी में है।
These assets are what? Similar to the partner. They remains with the properties.
बोलो
मनी के तौर पर है पार्टी के पास।
पानी के तौर पे
मनी
वो लोग को लिख के दिया है उसमें।
আগেরটাই কি Mr. Jain, where is the registered office of the judgment debtor situated?
जजमेंट डेटर का रजिस्टर्ड ऑफिस कहाँ पर है?
जवाहरलाल नेहरू नगर चौरंगी मेंशन सी ब्लॉक।
लाल नगर चौरंगी मेंशन
सी ब्लॉक।
सी yes sir.
What is the area? What is the size of the office?
जो ऑफिस है इसका साइज क्या है, कितने एरिया लेकर ये ऑफिस?
मेरे ख्याल में 10 बाई 10 का या 10 बाई 15 का ऐसा कुछ होगा।
10 by 10 feet.
10 बाई 15 फीट ऐसा कुछ होगा, कभी चेक नहीं किया बट हाँ इतना कुछ होगा।
The office space is measured 10 by 10 feet.
Is this registered office rented or owned by the judgment debtor company?
क्या ये जो ऑफिस स्पेस है ये क्या रेंट में लिया हुआ है या ऑफिस तो
भाड़े में लिया हुआ है।
ऑफिस स्पेस?
Can you show the rent receipts on the next date of hearing? Or have you holding the rent receipts with you?
आपने जो बोला ना भाड़े में लिया हुआ है, क्या भाड़े का रसीद आपके पास अभी है?
नहीं मेरे पास अभी तो
ये
नहीं
भी
होगा।
दिखा सकते हैं?
हाँ अभी कभी भी दिखा
I do not have the rent receipts right now, but I can show them on the next date of hearing.
Mr. Jain, in your affidavit, you have said that the judgment debtor has stopped business. Since when this judgment debtor has stopped business?
आपकी एफिडेविट ऑफ एविडेंस में आपने कहा है कि जजमेंट डेटर ने बिजनेस करना बंद कर दिया है। कब से ये बिजनेस करना उन्होंने बंद कर दिया है?
ये मेरी जानकारी में नहीं है।
I do not have that knowledge.
What business this judgment debtor is running at present?
ये जो जजमेंट डेटर है वो कौन सा बिजनेस अभी कर रहा है, बता सकते हैं आप?
नहीं
I do not know. I do not know.
You are the principal officer and yet you are not aware about which business the company is doing at present.
आप प्रिंसिपल ऑफिसर है, फिर भी आपको नहीं पता है कि ये जजमेंट डेटर कौन सा बिजनेस कर रहा है?
नहीं, मैं कुछ समय के लिए आया था तो मुझे बोला था कि आप डायरेक्टर बन जाओ।
नो, आई वाज देयर एज अ डायरेक्टर फॉर अ
सम टाइम, छोटे
for
टाइम के
a
लिए।
short period of time.
Mr. Jain, if the judgment debtor is not doing any business, why are you showing loss in the balance sheet?
अगर जजमेंट डेटर कोई बिजनेस नहीं कर रहे हैं तो बैलेंस शीट में आप क्यों दिखा रहे हैं कि लॉस होता जा रहा है?
वो मेरे जो पहले चार्टर्ड अकाउंटेंट थे उनसे मैंने ये लिखे, उनसे रिक्वेस्ट करके इसको बनवा के मैंने भेजा था।
I have requested my chartered accountant to make this balance sheet and send it to me.
On what account this judgment debtor company is suffering loss?
किस खाते में ये जजमेंट डेटर कंपनी को जो लॉस हो रहा है किस खाते में हो रहा है?
वो मा-
किस वजह से लॉस हो रहा है?
मेरे को बताया था कि कुछ जहाज के अंदर में कुछ मैकेनिकल इश्यू आ गए थे, उसी में ज्यादा खर्चा लगा, इसी वजह से ये लॉस में चला गया था।
Due to mechanical issues in the ship, that's why the judgment debtor went on loss.
Mr. Jain, how many employees are there in the office?
ऑफिस में कितने एम्प्लॉयज है, कितने लोग काम करते हैं वहां पर?
अभी एक भी नहीं होगा।
राइट नाउ देयर इज नो।
You just said, Mr. Jain, you are working as an employee in the company.
आपने अभी अभी कहा कि आप एम्प्लॉय के तौर पर उस ऑफिस में काम कर रहे हैं।
मैं पहले करता था, मैंने रिजाइन देने के बाद में मेरे यहाँ पे एक नोटिस आया था।
सर छोटा छोटा करके आई यूज्ड टू वर्क देयर। बोलिए।
तो मैंने रिजाइन देने के बाद में राजस्थान चला गया था।
आफ्टर गिविंग माय रेजिग्नेशन आई वेंट टू राजस्थान।
उसके बाद में मेरे पास में कोई सम्मन आया था।
आफ्टर दैट आई रिसीव्ड अ समन।
तब मुझे मालूम चला कि मैं अभी भी इस कंपनी में डायरेक्टर की पोस्ट पे हूँ।
अभी भी है।
हाँ,
अरे, I received a notice in Rajasthan, and on receipt of the notice, I came to know that still I am the director of the company. Yes.
Pausing here for a moment. This has been going on since 2022. What is happening whenever earlier occasion, I will draw your lordship's attention to an order dated 10 June 2022. Same thing happened. An employee came, deposed before, and Justice Shroff was clear that has to be filed by somebody who knows something. And lordship has seen this. Kindly look at the order, and lordship knows the future course of action. This is just wasting of time. Look at this. Earlier occasion, same situation. And there they have submitted Navneet Jain is the director. Now he is saying he is not a director. He resigned in 2017. This is playing with the court, my lord.
Okay, you examine, then you argue the matter, then the court will take a course of action.
I can go on, but as he is saying that he has resigned from 2017 and no answer will come. And also he submitted on that day, on 2022, his counsel said he was a director.
Correct.
And my lord, only director was directed to affirm. My lord, lordship sees the order, kindly have a look at order taken. And now see, and who has signed, and he is coming now saying that the same person is Navneet Jain. I make it clear in the absence of filing of such affidavits shall be issued against the directors. In the light of above, the directors are directed to file affidavit of assets. So that is the direction.
So why you accepted that when it is filed? Why you not pointed out?
My lord, kindly have a look at the affidavit. It says, my lord, I am the principal officer. So I thought the director is the principal officer.
It is
Now
not there. It is not there. Why you accepted that? And last occasion, several arguments were made. Then he wanted to examine. Now he is present.
no, I am ready to continue with the examination. I am just indicating the fact
Correct, but
that
you,
this is, my lord, bypassing.
no, not bypassing. It is the decree holder has to take steps, sir. It is the execution proceeding.
Lordship.
Correct. If it is execution proceeding, if we came to know there is no assets of the judgment debtor, what step is to be taken by the decree holder?
But I am not saying that. My lord, we have.
If they have not filed, then the consequence will follow.
My lord, I only want to demonstrate before your
जस्ट
lordship.
मिनट, आपका शिपिंग कंपनी था?
मैं उसमें काम करता था सर, डिफिंग
आप
कंपनी में।
डायरेक्टर है या मैं जो
हूँ।
पूछ रहा हूँ उसका जवाब दीजिए, ये कोर्ट
जी,
है,
जी सर।
आपका राजस्थान का गांव नहीं है।
जी सर।
आप इस कंपनी में डायरेक्टर है या नहीं है?
हूँ।
है।
हाँ।
रिकॉर्ड थ्रू कोर्ट वेदर you are the director of this company or not. Answer, yes I am the director. ये जो शिपिंग कंपनी है इसमें कितने शिप्स थे?
इसमें 5
शिप है?
हाँ।
Yes, there are 5 ships in the company. शिप का नाम बताइए।
अनंतपुर,
फुल
अवध।
नाम बताइए, एमवी है कि टीएसएस है, क्या है? शिप का नाम बताइए फुल।
पूरा
You
नाम
are the shipping line ना? How many types of the vessels are there?
अनंतपुर,
अनंतपुर,
अवध।
it is MV or TSS, what is MV?
तो फ्लोटे है
मालूम नहीं होगा।
MV अनंतपुर है कि खाली अनंतपुर है कि TSS अनंतपुर है?
नहीं, उसके आगे कुछ है।
हाँ मुझे मालूम है, मेरे पास सब कुछ है, मैं मंगा के रखा हूँ, मैं खाली आपको देख रहा हूँ आप कितने सच बोल रहे हैं। और अनंतपुर के बाद बताइए।
अवध, भद्रा,
भद्रा, यस, नेक्स्ट।
प्रशांति
प्रशांति
और एक मंजूरी करके।
हाँ,
मंजूरी।
ये शिप अभी कहाँ पे है?
ये शायद रिटर्न कर दिया था मेरे को।
ये शिप अभी कहाँ पे है?
मतलब these ships belong to I'm sorry
जानकारी में नहीं है।
I have no knowledge with regard to the ships. आपको किसने ऑथराइज किया कोर्ट में आने के लिए? सोच समझ के जवाब दीजिए।
मेरे पास सम्मन आया था उसी की।
आपको किसने ऑथराइज किया कोर्ट में बोलने के लिए जब आप यू आर नॉट इन द कंपनी? जल्दी बोलिए, आपने तो पूरा अकाउंट दिया है ना, कंपनी लॉस में है। हु हैज गिवन द अथॉरिटी? अदरवाइज पुलिस पर्सन्स आर देयर।
पुलिस के डाकू बोलছো
यू आर प्लेइंग विद द कोर्ट। अभी मैं टाइम दे रहा हूँ।
मेरे पास सम्मन आया था तो मैं ऑफिस में गया था।
आपको ये कौन बोला है कि एफिडेविट देने के लिए आपका कंपनी लॉस में है? मैं एक बात पूछ रहा हूं, क्योंकि आप तो राजस्थान में हैं, आप कंपनी छोड़ दिए, आपको किसने बोला कंपनी लॉस में है, एफिडेविट दीजिए।
मैं कंपनी के ऑफिस में गया, वहाँ पे सुमित पात्रो और एक अभिजीत दे करके थे जिनको मैंने।
आई वेंट टू द ऑफिस, आई फाइंड वन पर्सन सुमित पात्रो एंड
अभिजीत दे करके थे।
अभिजीत दे वेर फाउंड इन द ऑफिस।
उनको मैं जब देखे गया था अभी उन्होंने मुझे बताया था।
दे हैव एडवाइज मी, उन लोग बोले फाइल करो।
हाँ, उन्होंने बोला
दे
था।
हैव एडवाइज मी टू फाइल दिस एफिडेविट। सुमित पात्रा और अभी वो कौन है?
वो शायद शेयर होल्डर थे पहले जब मैंने उनको।
सुमित पात्रा एंड क्या नाम? अभी दे आर द शेयर होल्डर्स ऑफ किसका? कंपनी का, डिफेंडेंट का?
हाँ, कंपनी के थे वो।
कंपनी का, दे आर द शेयर होल्डर्स ऑफ द कंपनी।
जब छोड़ा था तब उन्हीं को ही दिया था मैंने, वो बता के।
व्हेन आई लेफ्ट द कंपनी आई हैव गिवन द सेट कंपनी टू दिस 2 पर्संस। हाँ, अब वो कहाँ है वो दोनों लोग?
अभी मालूम नहीं है, मैं काफी टाइम से।
आप तो बोले अभी ऑफिस में थे।
नहीं, मैं ऑफिस में गया था, मेरे पास में वहाँ पे मैंने पूछा था, सुमित पात्रो करके एक आदमी था, उनसे पूछा था तो उन्होंने बोला कि ऐसे ऐसे करना।
हाँ, तो ही तो सुमित पात्रो का एड्रेस बताइए।
घर का एड्रेस तो नहीं मालूम है, वहीं ऑफिस का एड्रेस में होगा।
I don't know the address of Sumit Patro. I know the address of this Sumit office address of Sumit Patro. क्या ऑफिस एड्रेस बताइए।
जवाहरलाल नेहरू, चौरंगी मेंशन, ब्लॉक सी।
तो आप मानते हैं कि एफिडेविट आपका अपना पर्सनल नॉलेज का नहीं है? क्योंकि आपको सुमित, आपका पर्सनल नॉलेज का नहीं है एफिडेविट?
नॉलेज में है थोड़ा सा।
आपका नॉलेज में है?
मैंने बस इसको पढ़ा है, पढ़ के।
जो एफिडेविट दिया आपका पर्सनल
हाँ।
नॉलेज, मैं बोल रहा पर्सनल नॉलेज है? I have personal knowledge from the affidavit. So you are taking the liability of paying the amount. आप जो है liability ले रहे हैं पेमेंट देने का.
कंपनी में जो होगा उसी से
आप liability ले रहे हैं या नहीं ले रहे, मैं पूछ रहा हूँ. आपने एफिडेविट दिया ना अपना लिए, आपने लाइबिलिटी, यू आर टेकिंग लाइबिलिटी ऑफ पेइंग द अमाउंट.
मैं तो कहाँ से दूंगा, मेरे पास तो होगा नहीं.
Record, I am not in a position to pay the amount, so I am taking the custody.
Lordship,
I am taking the custody.
I will make necessary
This
application.
witness has come here, keeping the person who is having all the assets. From the evidence of this person, Mr. You are very senior persons of the bar. Very.
May I only submit this, my lord? He has been authorized to file an affidavit of assets. He is before the court to be examined. He has been examined, my lord. Whatever was in his knowledge, he has stated, my lord. Now, my lord, before.
So why he not bringing the record? Who is the actual person, sir? Why he is suppressing the fact?
My lord, he is not suppressing the fact.
Why he is
Whatever
telling
was
that
there in
Sumit
his-
Patra and other persons? Why he have not stated in the affidavit? I have been authorized by so and so file the affidavit.
My lord,
There are
direct-
5 ships. Where are the ships? If the shipping company
Perhaps,
is
my
there,
lord, he is not the most competent person to
so
answer.
why
all
you have
this.
not stated that I am not the competent person?
He should
to file
have, my lord,
affidavit of
because
assets?
as I've learned, my lord, he has resigned. He has resigned, and his resignation has not been accepted in the sense it has not been submitted before the registrar of companies. So today he continues to be director, my lord. If now, my lord, whatever he had to say, he has stated, my lord. If my lord feels, my lord, that this the other 2 persons who have been named, if they have to be appear before the court with affidavit, they can
He's
appear.
not giving the address.
But he says
He's not
the
giving
office,
the total details. Let it,
Well, it
give the
appears
details.
he has said that they
Office
are.
address, I don't know.
He
They
does
will.
not have the residence address, my lord.
Why not? He is the company
Let him
director.
come back and tell my lord on the next day, or because he does not have the residence address with him. Now, if my lord directs my lord, he can find out and come and assist the court. But assuming worse, if my lord considers that after examination, my lord, the judgment debtors are concealing their assets, my lord, the hearing has to be done on this issue, and then my lord will pass necessary orders. Today, he cannot be sent to.
I will send. You challenge it.
Lord, hide and seek game going from
I don't think
2022.
Please,
But
sir.
my lord,
This court,
but
if
I
the
will
court,
not-
if
I
the
am the-
witness, I am not on the procedure. I am on that. On the oath, he is making a false submission. That I am sending it to the from here. I am not on the procedure. I am sending it. He is suppressing the fact, and on oath he is making the submission before the court. On that aspect, I am sending him into custody. So henceforth, nobody shall come before the court to give false evidence. That purpose. I am not telling, I am not sending with regard to the execution. I am sending him for giving a false evidence on oath before the court, that too in the High Court.
But I am in my
You,
lord's
you know,
hands.
you know better than me with regard to the Evidence Act. What would be effect of the false evidence?
Absolutely, but my lord will kindly, my lord.
And
This
you bring this
perfect
in a
elegance.
person, you could have been guide the person, but you have bring this person, knowing
has
that
to
he will
appear,
give
there
the
was
false
direction, he had
evidence.
to appear. I told him he has to appear in court. I had asked him to file an affidavit.
I am watching he's taking the eyesight from the your person. Sir, I was there in the bar for about 26, 27 years. How the witness is to be examined
But may
and
I-
how the witness is to be tackled when the witness is in the dock. I know. He was giving answer. His eye was there.
But may I suggest this, my lord?
So who is giving the gesture to him give answer?
May
I am not blaming the lawyer here. But I have to say in the open court with regard to the witness, what the witness has done in the open court.
May I only suggest this, my lord? If he can go back and find the address of these persons, and my lord can assist the court in that. My lord, kindly consider that he is an employee, my lord.
Not employee is telling that I am director. He's
not a
telling
shareholder.
that I am director. He himself is a confused.
He is not a shareholder, not a single shareholder is in his name. Shares in his name, my lord. He was made a director, and then he, after a brief period, has resigned. My lord, to whatever is there in
So
this
why he has
notice,
come here? You
but
could
he has been
have
authorized.
been director. I have submitted.
my lord, may I only suggest this?
Why he has submitted all this? The company is on loss. This is the loss.
That's the balance sheet, my lord. There was direction.
What direct?
There is
That's why who has given the direction. He has. You should have been mentioned in the affidavit.
The court
आप
directed.
बोलेंगे आप किसके डायरेक्शन में
No,
दिया
no,
है?
this court's direction to submit the balance sheets, my lord. So therefore, he had submitted, my lord. My lord, may I suggest this, my lord? Let him be examined fully, my lord, today, and well, he can come back and bring the information with regard to those principal officers, well, who has been just named, well, that's the best that this witness can do, well, this person can do, well. So, well, will kindly, and then if those persons don't appear, then, well, law will take its own course. But this person, well, is perhaps will be too harsh on him to be, well, sent to prison.
That
But I
required.
leave it to my lord.
Sometimes it required. Harsh is sometimes is required. Who is before the court on oath giving the false evidence. That
Perhaps not false, well, whatever he knows, perhaps he has stated.
Yeah, he intentionally he's telling that when he's not giving any answer when the question this court has put the question, all the thing has come.
The questions which are put before, well, perhaps
That I am not telling to the advocates. When the court has put the question, all the truth has come. Who is the director? What are the ship? What are the business? All has come. Till date, there is nothing on. There is no assets. Now the assets has come on record.
kindly consider, well, he was an employee for a very brief period, well, and whatever he knows, he has stated, well.
Why taking the risk?
Well, because there was an order, well, for him to appear, well. That's why he has come from, well, Rajasthan. Well, kindly gives
On
him
the
an
last
opportunity.
occasion, you also caution him.
Yes, he came, well. So, well, may I only suggest this, well?
He appeared
he can-
virtually. Lordship's
No, no.
direction thereafter, he came.
Then he came.
He was virtually.
Well, kindly, well, give him one opportunity. Well.
Let he file an affidavit stating that total the till date.
The
what is
whereabouts of
status
these
the
5
company,
vessels, well.
What is the company total status of the company? Who are the director? Who is running?
I shall
give
well, I shall-
total by Tuesday. You file an affidavit on that.
Well, if Lordship takes Justice Shroff's order, there is another director, Navneet Jain. He may also.
That's why
Yes,
you are.
for record,
I'm telling you are accepted that affidavit. You are not raised any objection on that
No,
day.
that's true.
Then
That's true. It was written principal officer. That's why I thought he is a director.
Well, will give a
that's
week's
the very
time.
first question I put to him.
Yes, well,
But
in
he
my
just said-
first question, he said I resigned on 2017. Lordship's question, he says I am still a director.
Oh, there is a difference between resigning and being a director. Unless it's submitted
Record
before the ROC, he cannot be technically not a director. So he has
The
resigned.
Judgment debtor is present in person. Full stop. The decree holder has started cross-examining the judgment debtor. Full stop. During the cross-examination, this court find during the cross-examination of the judgment debtor, this court find that the judgment debtor is suppressing several things and to hide the principal and the actual persons who are involved in the company, and also to suppress with regard to execution of the decree and making a false evidence before this court. During the evidence, it has come to know that there are other persons involved in the company who is running the business at present. It is also came to know the company is having 5 ships, but that all the things has not been recorded, not been disclosed in the affidavit of assets filed by this witness, filed by the judgment debtor. In view of the above, the judgment debtor is given another chance to file an accurate affidavit of assets stating all the assets and the persons who are involved in the business of this company, of the judgment debtor company, by 30th July 2025. Please, by serving the copy to the learned counsel for the decree holder, let the matter appear on 31st of July under the heading orders.
I'm deeply obliged.
Can it be Millard a day before or after Millard?
Then fix on 31st नहीं होगा.
Friday.
Then 30th. 30th July.
Not sure. But one thing I just want to point out regarding the ships, what happened in this case, the ships belong to Port Trust. They took all the ships, they used the ships, and
pay the higher charge.
not even 1 penny higher charge was paid, and that is the award holder, and we retained the ships.
Let
I-
all the things come.
Yes, just to assist your
All
lordship.
the
I said.
details, Mr. Please take care
Let
of
I
it.
and sit with them.
Please take care of it. This is the High Court.
I'll try Millard.
But one indulgence, lordship said, the name he has given, So their name and their details should she bring.
The
Name
persons
and
involved.
details.
The persons in
That Sumit Patru and Abhijit Dev.
the persons involved in the business. Last में करो. The judgment debtor is directed. The witness is directed to furnish the total details of the personals involved in the present case. In the business of the judgment debtor company.
I am deeply obliged. Very good.
Much.
Deeply obliged.
Judgment debtor. ठीक है.
My lord, this is an application by the defendant for seeking leave of this honorable court to disclose additional documents, my lord.
My lord, I am for the plaintiff late by Rajeshi Datta. He is coming, my lord.
Yes, madam. What are the documents? Why you are not filed the document?
My lord, these documents, my lord, could not. These are very relevant documents, my lord. I will tell your lordship what these documents are. My lord, one of my defenses to the claim of the plaintiff is, my lord, there is a difference in weight, my lord. These are weighbridge slips or kata slips, my lord, annexed to the invoices. My lord, about 500 invoices were disclosed by both the plaintiff and the defendant. These are admitted invoices. To 500 of those invoices, at least in 450 of those invoices, my lord, kata slips and weighbridge slips were annexed, my lord. My lord, this was missed, my lord. My lord, at page 6, paragraph 16, my lord, we have said, my lord, what had actually happened.
I'll file an affidavit, my lord. Disclosure, my lord, now it's very strict.
I understand that, my lord, but,
And I have already led my evidence.
but my witness has not begun, so he will still have an, my lord.
The defendant has filed an application being GA Com 4 of 2024, praying for leave to disclose additional document. Counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition be filed by 2 weeks. Reply, if any, there to be filed by 1 week. List the matter on 27th August.
Great. My lord, this matter, I'm appealing for the plaintiff, my lord.
Yes.
And we have filed an application being GA number 5, wherein we have prayed that since when the matter was filed, in the meantime, they have assigned the matter to another company, one ARC, and we have filed this GA with prayers of injunction restraining the respondent and the servants, agents assigned from giving effect to the further effect to the letter by which they have communicated about this assignment, my lord. After this, my lord, they have filed in their OA before DRT further documents regarding this assignment and also the assignment agreement, which was not with us. So, my lord, we want to, in such situation, we want to withdraw this application, file afresh with further documents, which we have found out later, my lord. For that leave, I am praying for leave to withdraw and file another application on this.
But how you can disclose in further document which you are not disclosed in the plain? This is a commercial suit.
My lord, since this assignment we have come
correct, then you have to take leave in the main suit, and in the main suit, then also in that application. I am allowing you to withdraw. Only I have been allowing.
Whatever the procedure has to be followed, that we will follow, and we will.
Because if it is not in the original suit, so it cannot be taken into consideration because it is commercial.
My lord. So we will follow.
I am allowing you to file a fresh. The counsel for the plaintiff prays for withdrawal of the present application due to some technicalities and prays for leave to file a fresh and prays for time fresh to file a fresh. In view of the submission made by the counsel for the plaintiff, GA Com 5 of 2025 is dismissed as withdrawn with the liberty to file a fresh. Yes.
But
Yes.
I'm for the petitioner, Malad. Malad, there is a mistake before I start. The cause title, Malad, one name of the profound respondent is left out.
Want to add?
I want to add. I was paying for leave to correct the cause title.
Give the file.
And this is application for judgment upon admission.
So in the suit, the party is not there.
In the
Suit,
in the
in the suit,
lordship.
the party's name is not appearing.
Yes, suit is appearing.
In the suit,
In this
in
application
application
only, it is by pro forma respondent. Malad, the judgment upon admission, and the admission is contained in balance sheet before filing of the suit, and two balance sheets after filing of the suit also, and balance sheets are signed by the directors and also auditors, statutory auditors. So that amounts to admission, my lord.
Not there. No check is issued.
Lordship?
Checks not issued.
Checks not issued. Checks not issued. The exact figure is telling in the balance sheet.
So there are three pro forma.
Three pro forma, lordship.
To add this.
Lordship.
You have sought the copy. Who is appearing for the defendant?
We have served the copy.
We have served the copy.
They are not. Laponi right, somebody is appearing, but they are not appearing.
Counsel for the plaintiff raised for leave. Submit that the plaintiff has filed the present application under Order 12 Rule 6.
Order 12 Rule 6, lordship.
Order 12 Rule 6, praying for judgment upon admission.
I'm for the defendant.
Okay, yes, because they have filed an application, but the performer defendant
Seek time for filing the report.
Affidavit.
No, they are praying for leave to add the performer defendant in the application, allowing it. So let the add, then the copy will be served to you. Then you file.
Copy served.
Copy is served.
Copy
But
served.
that amended.
Amended.
Added.
Yes,
The previous application was served.
So that has to be added.
And if they want to file affidavit, my lord,
I will.
that can be granted.
Okay. Judgment upon admission. Judgment. Rule 6, praying for judgment upon admission. Counsel for the plaintiff submitted. After going through the application, the plaintiff came to know that in the main suit there are 3 pro forma defendant, that is defendant number 2, 3, and 4. But inadvertently, in the present application, the pro forma defendants are not made as party to the said application. Accordingly, press leave to add the name of the pro forma defendant in the present application as defendant number 2, 3, and 4. Consider the submission made by the counsel for the plaintiff. This court find that the leave prayed for by the plaintiff is formal in nature. Accordingly, the plaintiff is granted leave. The advocate on record of the plaintiff is granted leave to add the name of the pro forma defendants number 2, 3, and 4 in GA Com 5 of 2025 within by
tomorrow, my lord?
By 24th of July 2025. And the amended cost status may also be served to the learned counsel for the defendant. Counsel for the defendant raised for time to file affidavit in opposition. Let affidavit in opposition be filed by
The defendant number 1.
counsel for the-
1 week, my lord, enough.
within 1 week. 1 week. Within 2 weeks.
Reply is actually ready. It's just
Within 2
waiting for
weeks, reply if any there to be filed within a week thereafter. Please the matter on 19th August.
I am deeply obliged, and I tender unconditional apologies for this mistake. Well, very silly mistake. Well, a typo mistake, man. Deeply obliged.
Oh, sorry. I am for the plaintiff in this testamentary suit, my lord. Today the defendant was supposed to.
My lord, if your lordship recollects, yesterday I had mentioned, my lord, out of turn, upon notice, my lord, my witness is not available due to a health situation, my lord, and this is the copy of the medical certificate that I've received. He's having shortness of breath. His witness action was supposed to start today.
It was mentioned yesterday in the morning, and this report I see is in the evening. So they knew before the report
I
came.
have a previous 1 month back report also with me.
So why mention at the last moment?
Yeah.
Why mention at the last moment if he's suffering from this?
See, this court has made up my mind.
I had to pay
Unless
cost
the
of
advocates are
50,000.
not ready to adduce the evidence, I will not impose. I fed up with the act of the advocates of the bar. They are not interested to proceed with the matter.
My witness
Only
was
our persons are interested with interlocutory. That's why I also not take interlocutory once in a day one. If you are not proceeding the suit, so why the interlocutory you are pressing for?
I suffered, my lord. I had to pay 50,000
What
costs
can be
in
done?
one matter, my lord.
What can be done? That's why I'm
This is
telling.
at the last moment.
I have taken all the.
Because one adjournment will push back the matter by another 1.5 months, my lord.
Correct,
This
sure.
is the testamentary suit. They cross-examined our witness for 7 or 8 occasions, and it never came that the defendant was suffering. And suddenly, just one day before,
The matter is fixed, especially fixed today for witness action of the defendant. Yes,
my lord, defendant, my lord.
of the defendant's witness for examination of the defendant witness. But the counsel for the defendant submitted the defendant is under medical treatment, and as such, it not in a position to. And as such, the witness is not in a position to appear before this court today, and it paid for adjournment. Counsel for the plaintiff raised objection and submitted 2 months before the case is fixed for witness action, and at the last stage, the defendant has prayed for time. Considering the submission made by the counsel for the parties, for the interest of justice, the case is adjourned. Let them argue the matter. 2nd September at
Can
2
it be a shorter date, my lord, if possible? And unless they have to indicate. Otherwise, on 2nd of September, another prayer for adjournment will come.
I will, there is a further condition I am imposing on that. 2025 for examination of the defendant witness, it is made clear that on the date fixed, if the defendant failed to appear, evidence on the side of the defendant will be closed. Yes.
Grateful to my lord. I apologize. We can have this, which is.
Yes, I know. Yes.
I appear for the plaintiff, my lord. The respondent
Please,
number 2
please, your lordship.
taken out an application. One is under Section 8 and one is under 12A, revocation of the discrete.
Two applications.
Two
So there are two applications, GA2 and GA3. GA2 is actually for Section 8 of the Arbitration Act, where there's an arbitration agreement in respect of the agreement on which they base their claim on. And GA3 is Section 12A of the Commercial Codes Act.
Okay.
My submission is Section 12A really should be taken up first, because if the court doesn't have jurisdiction, then the question of Section 8 will not.
Yes.
One thing before I start, we have only a copy of GA1, which is their petition. And I'm basing my case because I don't have, we don't have a copy of the plaint. So basis of GA1, I have to make my submission because they have not given us the
But
first I would like.
Writ of summons not served.
No, writ of summons is not.
Take scrutiny in the department.
Yes.
Because I think the suit was instituted in May 2025. It should have been already June, July. We are in July. Kindly first look at the order which was passed with regard to 12-way leave. There's no reasoning given, which will find in the reply affidavit reply in GA3. Affidavit reply.
Yes. Paragraph
no, my lord, page 18 is one of the order.
Yes. Order to Rule 2 and Clause 12 of the latest patent.
So there's really, my lord, no reasoning at all. The compliance of the requirement of compliance under 12 of the commercial codes is also dispensed with. No, this is, my lord, what the. My lord, I'll just give the background, little bit of background.
Yes.
My lord, the plaintiff claims.
Yes.
They had, my lord, given
Yes.
money to respond number 2, defendant number 2, under an agreement of 21st June 2012. In respect of certain monies, my lord, which we had to pay for the purpose of, my lord, acquisition of shares. In respond number 1. This was one of the transactions on which, my lord, they based their claim. We, my lord, respond number 2, had, my lord, filed an arbitration proceeding which has been pending for quite some time with regard to, my lord, specific performance of the shares were not given to us, and, my lord, we had filed, my lord, the arbitration agreement for the purpose of, my lord, obtaining specific performance. We could not, my lord, get specific performance. In the end, whatever money was, my lord, given by us on the concession of the other parties, my lord, it was, my lord, told, directed that, my lord, those monies will be given back. From 2012, there has been, my lord, no demand by, my lord, this plaintiff who said they had given money. Our cases, my lord, which we have not yet, my lord, saying that this was all squared up, and though initially you had given money, but there's other transactions which were there, so there's no question of really you getting any money. But that is on the merits of the matter. Now, my lord, they then, and, my lord, this went on, my lord, first, my lord, the award was passed. Then, my lord, we filed, they filed, the other side, my lord, filed a section 34 for setting us up the award. We were successful there. They filed, my lord, an appeal. The other side, my lord, again, my lord, respond number 1 here. Filed an appeal that was also dismissed, so, my lord, the award survived. Then, my lord, before the Honorable Supreme Court, again, my lord, they went to the Honorable Supreme Court. Honorable Supreme Court then, my lord, directed that whatever money was deposited, that would be given to me. And, my lord, the SLP, my lord, is
still lying.
The specially petition, my lord, is still, my lord, pending. And this was, my lord, in yes, the principal was paid. There was an issue with regard to interest. That is, my lord, now also, my lord, pending before the Honorable Supreme Court. Then, my lord, they filed a suit saying that you cannot take the money, withdraw the money on the basis of the 2012 agreement. And, my lord, I'll show their pleadings where, my lord, they were.
And the arbitration in terms of which agreement?
In, my lord, the agreement not between them and me. Other agreement, my lord, between respondent number 1 and respondent number 2. There were other parties also, but basically, my lord, I was going to buy shares, my lord, in respondent number 1. So that is, my lord, the original agreement between two parties. And they say, my lord, they had given money, which I had, according to some part of the money, my lord, I had paid, my lord, share consideration, my lord, substantial amount. Out of that, my lord, they say. So they filed the suit, moved it, and immediately after, my lord, the order of the Honorable Supreme Court, when I was directed to, my lord, get the money, after, my lord, all this, my lord, long fought, my lord, arbitration of, my lord, about 10 or 10 years. Then, my lord, they came and said, no, you can't give the money. Now, my lord, we showed, my lord, from the petition at that point that, my lord, they had knowledge on the face of it. First of all, my lord, they did not pursue the matter at all. And anyway, they had knowledge, my lord, from 2024 onwards, which they themselves admit. So, my lord, no question of urgency or no question of, my lord, saying that now I want urgent relief, therefore I can file the suit and have, my lord, a dispensation of section 12. Now, my lord, after the suit was filed, my lord, the learned judge, my lord, thought that if it can be resolved. So there was, my lord, an informal, we were sent, my lord, really to say, my lord, was it mediation? My lord, informal to, my lord, a person, my lord, so a learned advocate, my lord, where, my lord, learned senior advocate to see, my lord, whether we could resolve a difference. That was not done. Could not be done, my lord. That was, we went there, but, my lord, it could not be, my lord, sorted. So that aspect is there. I don't know how, my lord, that would be used by my learned friend to say, no, we have already done mediation. If at all, my lord, I'm successful to show, my lord, there's no. No, my lord, kindly so take, my lord, GA1, because that's all I can proceed to show, my lord, that there's no urgency, my lord, pleaded or shown for the purpose of, my lord, GA1, my lord, will take, and my lord will find Defendant number 1 is a long-term lessee in respect of premises number 6, Jawaharlal Nehru Road. This is one of the property concern. Then till the time hereinafter, the defendant number 8 to 19 were the shareholders, defendant number 1. Defendant numbers 4, 6 and 8 to 19 are ostensibly still the shareholders of defendant number 1. Then defendant numbers 2, 4 and 6 are companies. This is me. Defendant number 2, 4 and 6 are companies within the meaning of the this one 2 is me. 4 malad I'll show malad, that's Orbit, that's again malad another person malad who wanted malad shares, and 6 malad is also malad another. So 2 I am 2. 2, 4 and 6 are company meaning of the Companies Act. Respondent 3, 5 and 7 are the principal officers and directors and a person in control of respondent 2, 4 and 6 respectively. Then 3. Sometime in January 2012, the respondent number 3 on behalf of the respondent number 2, respondent 5 and 7 approached the plaintiff's director Rajiv Agarwal and represented as follows. Respondent 1 was the lessee of premise number 6, Jawaharlal Nehru Road, hereinafter referred to as the said premise under registered deed of lease dated 21st December 2020. B. Respondent 2 along with respondents 4 and 6 are directors by respondents 3, 5 and 7 and entered into a share purchase agreement dated 24th March 2011 with the respondents 8 to 9 to acquire all the shares of and respondent 1 for a sum of rupees 82 crore, out of which a sum of rupees 20 crore was to be paid as consideration for the aggregate number of 36278 shares of and respondent 1 held by the respondent 8 to 19. Now, this is the agreement under which my arbitration took place with the other group.
Okay.
This is 24th March 2011. Then, and the balance sum of 62 crore was to be given as loan. Then, C. Respondents 2, 4 and 6 had entered into an understanding dated 4th August 2011, wherein it was agreed by the parties that the shares of the respondent 1 would be purchased in the ratio of 36%, 36 to 46, which I am, to 18. That is 36 to be acquired by respondent 2, which is me, 46 to be acquired by respondent 4, which is another party, and the remaining 18% by respondent 6. Then purpose of acquiring the shares of the respondent number 1 was to exploit the leasehold right of the respondent 1 by constructing a new building at the said premises and subletting the same. Then respondent 2 did not have the funds required to make payment of his share of the constitution under SPA for acquiring 36% shares of respondent 1. The respondent number 2 would sell and transfer 18% of the shares of the respondent 1 to the petitioner. So this is now they come into the arrangement according to them. Out of the 36% shares which would be allotted to in terms of SPA. In this regard, respondents 3, 5 and 7 made over a copy of the share purchase agreement dated 24th March 2011 to the petitioner, and a true copy thereof is annexed here and marked and part of the plaint and marked as annexure A. Then let's see paragraph 4. Relying on the representation made by the respondents 3, 5 and 7 on behalf of the respondents 2, 4 and 6 to the plaintiff's director, the petitioner agreed to purchase and or acquire 18% of the total issued and subscribed paid up equity shares of respondent 1 for the consideration of 14.72 crores and on the terms and conditions mutually agreed between the parties sometime in January 2012. It was further agreed that the agreement arrived at by and between the parties would be recorded in a memorandum of understanding. Pursuant to the agreement between the parties, between the petitioner and the respondent numbers 2, 4 and 6, the petitioner remitted rupees 1 crore 20 to the respondent 1 and rupees 80 lakhs to the respondent 2 on 17 January 2012 by RTGS. Petitioner has made payments. Petitioner paid rupees 18 lakhs only by check to the respondent 1 on 7th June 2012. So they're saying they paid to me directly as well as to respondent 1 whose shares I was to purchase. Then respondent has made payments. Then paragraph 7. Between 17 January 2012 to 30th May 2012, petitioner paid an aggregate amount of rupees 4 crore 66. 4 crore 66 to the respondent number 2. Petitioner has made payments for his registrar of his answer. Then paragraph 8. Pursuant to the agreement of January 12, the petitioner and the memorandum respondent numbers 2, 4 and 6 executed a memorandum of understanding dated 21st June 2012. Hereinafter referred to as the said MOU, in terms whereof the respondent number 2 agreed to assign and or sell the 18% of the total issued, subscribed and paid up share capital of the respondent 1, being 50% of the total equity shares of the respondent 1 to be acquired by the respondent 2. The said MOU was executed the office of the respondent 2. 3. So this is the relationship between me and him. This is the basis on which he makes this claim in this suit.
So you are appearing for only 2.
I am appearing for 2.
4 and 6 nobody there.
No.
Orbit and Damani.
Page 80 is the agreement. Kindly come to my lord page 80.
There is an interim order.
No, no. No, my lord, my lord, when we was sir, my lord, we registered the interim order, no interim order was passed.
Yes.
Because my lord, we came and said, my lord, it's my lord, the agreement is of 2012. You have never raised any issue with regard to the 2012 agreement. The arbitration has been going on for such a long time. Now to come and say that you secure my claim.
Yes.
When I am about to receive money, because this money was deposited long time back, my lord, when the section 34 and section 36 was filed.
When the 34 was, when the award was passed?
My lord, award was passed. My lord, give me the date of the award, please. I just, my lord, it's my lord mentioned.
In that the plaintiff is not the party over there.
No, plaintiff is not. Because that is an agreement between
you and the other respondents.
Me and the other respondents, where I had put in. So he was nowhere, my lord, in that sense, my lord, not in the arbitration at all. He had a side, according to him, he had a side agreement with me, where he had given me part of the consideration,
this one,
which had paid. And this is in 2012. My lord, award is, my lord, 29th June 2023. Order gulo bolo na ache. Dismissed.
Yes.
Section 34 dismissed. Now, my lord, kindly come to, my lord, page 80. Memorandum of Understanding, my lord, is made this 21st day of June 2012.
Yes.
Between Jagriti, that's me, company incorporated Sunsach, transferor, repugnant to the condition, mean to include success and interest of the first, and Tirupati Vancom, who's my lord, the plaintiff petitioner here, having its registrar office at Sunsach, referred to as transferee, shall, unless excluded by or repugnant to Sunsach, second part, and Orbitas and Damani are confirming parties because they were the ones followed who were taking the balance share. So 36%, 46%, and 18%. I was to get 36%, 46%, and 18%. Now I never got the 36%. In the arbitration, my lord, I failed. I was not, though they got the 36 and 18%, I never got, my lord, by 36%. Then, my lord, whereas, my lord, sees one James Glendie and company in the meaning of Sunset, seized and possessed of all that municipal premises. 6, my lord, all that is given. Then, my lord, B is project. Then, my lord, C is with the intent of acquiring, B is important, with the intent of acquiring the leasehold right of the company in the said property for the residue unexpired term of the head lease and of developing the said property into a commercial complex and commercial exploitation of the same, hereinafter referred to as the project. The transferor and the confirming parties hereto, by an agreement dated 24th March 2011, made between Deepak Bhargav, Rajni Bhargav, Deepak Bhargav, Sanjay Bhaivam. So these are all of the shareholders of Response number 1.
Correct.
So 2, 4, and 6 are buying 100% shares of 1 held by the other respondents 8 to 19.
90.
And plaintiff in 2012 had given me part of the money insofar as Mullah 2012 agreement is concerned. This is Mullah the, then Mullah sees paragraph page 82. To effectuate such assignment and transfer. Now, how much this agreement survives also, we don't know, but let us not be, that's on a question of merits. To effectuate such assignment and transfer, transferor has agreed to cost to be transferred by the above named present shareholders out of its proposed allocated shareholding agreed to be purchased by the transferor from the present shareholders under and in terms of the share purchase agreement, 18% of the total equity shares of the company held by the present shareholders directly in favor of the transferee by nominating the transferee to the present shareholders to complete the transfer of such 18% shareholding of the present shareholders in the company unto and in favor of transferee. The consideration payable by the transferee to the transferor for such, so they have to pay, for such assignment and transfer has agreed has been agreed to be rupees 14.76 crore, out of which only rupees 3.60 crore shall be towards the consideration for purchase of 18% of total equity shares of the company, and balance sum of 11.16 shall be towards 18% of the total loan amount agreed to be provided to the company under and in terms of the said share purchase agreement. The said consideration of 14.76 crore shall be payable by the transferor to the transferee as follows. Then 16.03 has been paid as earnest money. Execution 1.35 crore shall be at time of installment. Balance consideration 7 shall be paid. Then C, my lord, consideration 7.38. Then, my lord, kindly come to, my lord, 3.2 at paragraph 83. In addition to the said consideration of 14.76, transferor has agreed to pay the transferor 18% of all costs, charges and expenses to be incurred for the said project, inter alia under sanction, including sanction fee, brokerage, architect's fee, and such 7 days of request to effect the transfer being recorded. Then, my lord, just take 2 or 3 more clauses, and then, my lord, we should kindly come to page 84. Clause 8, my lord, first, kindly see, my lord. In case the transferee is ready and willing to comply with its obligations herein, contained in spite of present shareholders completing the sale and transfer of the shareholding of the company in favor of the transferor, and the confirming parties the transferor fails to cause to be transferred the said 18% shareholding in the company, pair of transferee shall be entitled to sue the transferor for specific performance of the contract envisaged herein. Then 9, in case due to any reason said share purchase agreement is cancelled or terminated, the transferee shall be entitled to the refund of the entire money until then paid by the transferee to the transferor immediately upon the transferor receiving the same from the present shareholders and or the company, as the case may be. Then it is made 10. It is made clear that the transferee has already agreed to purchase 18% total equity share in the company.
So 9, in case due reason the said share purchase agreement is cancelled.
Cancelled or terminated. Cancelled or terminated. My lord, nothing like that here, my lord, because the award, which is, my lord, in 2023, that says I'm not entitled to specific performance. There was a dispute, my lord, with regard to which agreement was really, my lord, being because we, my lord, showed an agreement which had, my lord, different consideration. They showed an agreement which had different consideration, and then, my lord, we also, it was held that we are delayed. Both had asked for specific performance. That Deepak Bhargav group, my lord, Reswana 1 and Deepak Bhargav, they also failed with their specific performance. I also failed, my lord, with my specific performance. My lord, 9 is, my lord, it has to go back. But then, my lord, 10, it is made clear that the transferee has hereby agreed to purchase 18% of total equity shareholding and not the 18% shareholding of the transferor agreed to be purchased by transferor under the share purchase agreement. Then, my lord, any dispute arising, 11 is very important. So far as the section 8, any dispute arising out of or in connection with this memorandum between the transferor and the transferee, including a dispute regarding the existence or validity or termination of this memorandum, or the consequences of its nullity, shall be referred to and finally resolved by arbitration of such person or persons as may be mutually appointed by the transferor and transferee. The arbitration shall be conducted in accordance with Arbitration and Conciliation Act. All proceedings in such arbitration shall be conducted in English. Only the Honorable High Court.
Yes.
So this is, my lord, how.
So what they have claimed in the plaint.
Now, my lord, kindly come to, my lord, in the plaint. Plaint, my lord, we don't have. I'll show, my lord, the reliefs which they have claimed. My lord, in GA1, I, my lord, had stopped at page 8, my lord, I had shown up to paragraph 8. Then, my lord, they set out the clauses of the memorandum. We can skip over, my lord, all those clauses. Then, my lord, if my lord wants to look at, my lord, the reliefs, that is at page 28.
Award dated 29th
Yes.
June 2020.
I don't know how, my lord, that.
Yes.
This award, my lord, is the other award, because that award directed money has to be paid to me. So they say declaration that the award dated such are not binding on them. Then, my lord, they're all money claims. So there's no, my lord, urgency with regard to, my lord, money claims.
Yes.
And urgency, my lord, with regard to an interim application also has to be, my lord, in context of, my lord, the claims which they make. Then my lord, E and all that, my lord, is gone. E and F. Now, if my lord kindly comes back to my lord page 14, where my lord, page 14, my lord, paragraph, just before paragraph 10, we came up to the MOU. Then my lord, see 10 quickly, my lord, subsequently, respondent 2 represented the petitioner that it had duly remitted the monies received from the petitioner prior to the execution said MOU to the respondent 1. Respondent 2 requested petitioner henceforth make payment directly to respondent 1. Then my lord, 11 is they say they made payment 2012 and 31st March 2014. And then my lord, paragraph to page 15, paragraph 12, according to them, my lord, another 25 lakhs paid. Then my lord, 13, sometimes after March 2014, kindly look at the dates, the respondent numbers 3, 5 and 7 informed the plaintiff's directors. C, my lord, is the person controlling 2, according to them, that although the original plan was that the new building would be constructed by the respondent 1, they had now resolved to engage a developer to carry out the said construction. Petitioner was informed respondent numbers 3, 5 and 7 representing the respondents 2, 4 and 6 had negotiated with one Siddha Real Estate Development Private Limited for developing of the said premise in terms of the respondent 1 would be entitled to 7 floors along with corresponding car parking space, and developer would the balance 9 floors along with corresponding car parking space. It was further represented to the petitioner that with the induction of a developer, liability of respondent 2, 4 and 6 under the SPA would stand reduced, and such reduction would also inure to the benefit of plaintiff. Further make clear the induction of the developer, the entitlement of the petitioner and respondent 2, 4 and 6 to the share of profits of the respondent 1 would now be limited to revenue generated from 7 floors and corresponding car parking spaces. Petitioner agreed with the proposal mooted by respondents 2, 4 and 6. So very important. In 2014, according to their case in the plaint, there is a modification of whatever this arrangement is, and they say they were agreeable to the proposal which was given to the respondent 2, 4 and 6, saying now our share of profit will be restricted. Then 14. Subsequently, petitioner was informed by the respondents 3, 5 and 7. Respondent 5 had executed development agreement on behalf of Siddha. Then paragraph 15. Petitioner was required by the respondents 3, 5 and 7 to make and duly made payment of 1 crore 85 lakhs on account of consideration for purchase of 18% shares of and the respondent 1. This amount was rounded up figure of 18% of 10 crore 24. Payment of a 1 crore 84 was made by petitioner respondent number 8 to 19 of the respondent 1, and particulars were given in schedule annexed A2 and marked F. So very interesting. So they say they made this payment to 8 to 19 directly, according to them.
Correct.
Then kindly come to paragraph 16, where they say they paid 4 crore 73.
These are 3, 4, 5 and 7.
Yes. To at our insistence, they paid, at my insistence as well as the other ones who got the shares, 473, respondent 1 account of loan. Then according to them, they paid 11 crore 24 lakhs.
Correct.
Then not required to then 18. Accordingly, petitioner did not make any further payment. And these are all done by 2014. Last payment.
No.
I'll just give the
Para 17. Upon making payment of aggregate of 11 crore, as stated herein above,
yes,
it was represented to the petitioner by the respondent number 3, 5 on
not required to make any further payment.
Okay.
Not required to make any further payment. That's what they say. Then 18, accordingly, the petitioner did not make any further payment, nor was it called upon to do so at any time by response 3, 5 and 7, respondent 1 or the outgoing shareholders being respondent 8 to 9. In fact, breaking account now transpires that the petitioner has paid rupees 2 crore 89, 2 crore 39 in excess of its share of payment of rupees 7 crore 43. Then paragraph 19. Again, nothing with the. Now, all of a sudden, we jump to paragraph 20. So we were restricted to 2014 first. Now, all of a sudden, 10 years later. Now, very interesting. Sometime in July 2024, petitioner was surprised to receive a notice from the Learned Mediation Center High Court at Calcutta for mediation of a commercial dispute filed by the respondents 1, 8 and 9. So James, the one, my lord, in which I had to buy shares, by this time, my lord, the award is already passed.
Correct.
So they filed a suit against the
Petition.
petitioner and the respondent numbers 2, 4, and 6. Copy of the notice dated 15 July issued by Learned Mediation Center, High Court, Calcutta, the next statement marked H. On receipt, my lord, I'll show, my lord, that H in notice on record.
So there is another suit.
Another suit. Now what they did, this matter, my lord, has wheels within wheels and, my lord, like that. So one, my lord, who was to make payment to me, James Glendy, where, my lord, the award is now passed that he has to return me the money. Whatever money I paid, because it was accepted, the money was paid on my behalf. They filed a suit saying that, and I'll show, my lord, the relief star. They filed a suit against all of us to say that they are not liable
To pay the annual.
Yes. They should not be made liable. The award is only relieves them of any obligation. So, Mullah, that is in July 2024. So, he has knowledge of the award in July 2024. Because, Mullah, by this time, Mullah, the award is already there. Mullah, that's, Mullah, in 29 June 2023. And Mullah, this, Mullah, just for the prayers, Mullah, will find. Mullah, in volume 2, volume 2 of, Mullah, the application. Award होता है next को अभी तो जानते हो. No, the award is also, my lord, annexed. They were aware, my lord, everything. My lord, page 240. So this is, my lord, the other suit which is filed now, my lord, by the award debtor. Award debtors, really, my lord. James Glendy, my lord, sees, who's won in this suit also. Then Deepak Bhargav, my lord, who was the original shareholder. Then Rajni Bhargav, his wife, my lord, that's at 241. Versus, my lord, sees Jagriti Trade, which is me. Then, my lord, turns over and sees 242. Different number 4 is, my lord, Tirupati, who is, my lord, the plaintiff here.
Yes.
And the relief, my lord, will find at page 266.
250?
266, my lord. Four is him. My lord, in the prayer, my lord, file 266. A decree of declaration declaring that the plaintiffs, which is, my lord, James Glendy and Bhargav, that the plaintiff discharge of all liability, defendant number 3 and defendant number 4. 4, my lord, is Tirupati. And 3 was, my lord, another party, my lord, who had another person, my lord, who had, my lord, given me some money, my lord, to put in. That is, my lord, also. In respect of the amount of payment of the settlement 69 lakh and 6 crore 57 together with interest. Then alternately, a further decree of declaration award dated 29 June passed in the arbitration between defendant number 1 herein and the plaintiff's hearing is binding on defendant numbers 3 and 4.
Defendant number 3 and 4.
3 and 4, my lord, is at page 242, my lord, will find. 4 is Tirupati.
You are not there. You are 1.
I'm 1. I've got the award. So first suit, my lord, by James, they're all together. My lord, that was our submission, obviously made that, my lord, the money should not come to me. So James files saying, please hold that it is binding. The award is binding on 3 and 4, including him. He files the subsequent suit, which is this suit, saying it is not binding on me. So he also, my lord, asked for that relief. That's prayer A. My lord, in this suit, my lord, I showed prayer A, my lord, will recall at page 28. So there are several other points, my lord. I am only on the question, my lord, of 12A. How to, my lord, how this suit is maintainable also. Page 28, my lord, of the first volume, my lord, sees declaration.
Between the defendant is binding and does not affect the right at the interest of the plaintiff.
So he says award is not binding on him. And James Glandy says award is binding on him.
Yes.
Then, my lord, C is a decree of permanent injunction restraining the defendant, each of them from claiming a sum of rupees 7 crore 27 with interest, if any, pardon portion. Then D, mandatory injunction directing defendant numbers 3 and 4 to have their claims against the plaintiffs for alleged advance made on behalf of defendant number 1 be entered. And kindly see, my lord, the collusion, my lord, should be writ large on their face. But, my lord, that I'll save my arguments for another day. Be entered and adjusted from the fund deposited with the registered original side in terms of order date 18 December 23 passed in AP. And he says, my lord, that the fund should not be withdrawn, and, my lord, the registrar should pay the money to him. So what I'm showing is, my lord, he's aware of what reliefs have been asked for.
So where is the fund now?
Fund is with me because he did not get an interim order. The principal, my lord, whatever was direct.
You are
Yes, yes. Well, it's my money. I, my lord, fought, my lord, for the last 10 years, my lord, to get this money. As soon as, my lord, the award fructified, I'll tell my lord what happened. As soon as the award fructified, finally, my lord, when we went to the Supreme Court said, no, pay him the principal amount. As soon as we got the order, next day, my lord, this suit was filed.
Okay.
Because in the earlier suit also, which, my lord, I'm showing at page, my lord, this 267, no interim order is there.
Correct.
No interim order is there. And the similar reliefs asked for. One says it is binding.
So what is the stage of this suit? 266.
My lord, এটা কি আমাদের সার্ভ করেছে
Lord, I am appearing on behalf of the defendant number 1. Lord, Lordship knows, Lord, CS 764. Lord, Lordship was hearing, Lord, the written statement of my learned senior friend's client that has been, Lord, struck off. Lord, the right to file. Lord, we had argued this matter, and Lord, that is the stage of the suit so far. Lord, Lordship, by an order, I believe, Lord, 18 July 2025, Lord has directed that.
3 and 4 has filed.
Lord, defendant numbers 3 and 4 have filed their respective written statements. Lord, that is the stage.
So in that case, there is no interim order.
I have filed. I have filed. I have filed my written statement in this other suit, in which he is the plaintiff.
No, now stay.
No interim order.
Beg your pardon?
No interim order.
No, that suit was filed after pre-institution mediation. That
And
suit
this
was filed after
without pre-institution mediation.
Correct.
Yes.
So that is, my lord, my grievance.
Right, well.
Yes, that is my grievance. Saying in July 2024, you get a very similar suit.
So you have filed an application for revocation because there is no urgency.
Correct. All, my lord, from July 2020, you or yourself pleading says you are aware from July 2024 with regard to the subject matter of this very suit.
And
Of this very suit.
When you have obtained the amount? When you have received the
My
amount?
lord, on May, my lord, 19th, 18th, 19th. Yes. My lord, when they filed the suit, they asked for interim order.
After this suit was filed.
My lord, they filed the suit. They came for interim order. We, my lord, quite naturally resisted, saying that you are not entitled to it. All this money you already received long time back. In any event, this is a money claim. You cannot have it. And you are waiting in the side. As soon as Supreme Court has said after 10 years, I should get the money, you've come. That was our ground, my lord, to resist. Because 9th of May, my lord, is the order of the Honorable Supreme Court. And 16th of May, my lord, this was moved ex parte.
In that case, Mr. Banerjee, whatever it may be, okay, 12A, urgency. Why you are pressing for this? Let the matter be decided and you go with this section 8.
My lord, according to us, my lord, the suit is also, my lord, not maintainable. Because this kind of, my lord, urgency leave.
That's correct. No,
Because it is, my lord, after all, my lord, the statute book has it.
Division bench order is also there. Once the leave is granted, though I have passed several orders for.
My lord has passed, my lord, several orders saying, my lord, it's a. No, because I'll tell you, my lord, what, my lord, sometimes it might seem like, my lord, a futile exercise. Sometimes. But the question is, my lord, whether the letter of law should be respected or not. That is also one of the questions, because that's why my lord has seen my lord partial automation, my lord, including my lord last one, my lord has considered everything. My lord, Yamini is there, then my lord Dhanbad fails, my lord is the last one which is coming. Because this is my lord an abuse. The whole idea, my lord, in mediation is not to have an abuse of the process.
Okay.
Because today, my lord, they come in. My lord, it's correct. Maybe section 8 and all that, my lord, will come. But my lord, with great respect, my lord, if I put my submission question from, were they really entitled to come and sit when they know from July 2024? That's why I showed, my lord, the plaint is very important, because 242, 240, my lord, the plaint, and my lord, the reliefs, 266. 266, my lord, is looking at, my lord, the reliefs, my lord, which was in respect of, my lord, the July 2024 suit.
Yes.
Because from 2012, 2014, last payment made, and up to, my lord, 2025, my lord, no demand.
Correct.
Only in 2024 all this happens.
Where is this? The present suit you are not having, na?
No, my lord, I don't have, my lord, a copy of the plaint.
You don't have a copy.
We don't have a copy, my lord.
What is the urgency rate for in the print?
My lord, if my lord comes back, my lord, to the petition, my lord, I find, my lord, page 18 I was showing, paragraph 20, 21.
Page 20.
My lord, page, sorry, my lord, paragraph 20, page 18, my lord was looking at.
Yes.
My lord, if they could also, my lord, give us, my lord, a copy of the plaint, my lord, we can also come. Oh, after the injunction. Sure.
That's a letter of the law.
Or, my lord, they can give it after, my lord, the
That's
dismissal.
the letter of the law.
My lord, they can give it after dismissal as well.
Either way, we'll see which way.
Since, my lord, my learned friend, my lord, is
That's why I generally I directed first the suit should be registered, then injunction application
Correct.
will be taken.
Correct.
Because I find two
Yes,
difficulties.
yes.
So that's why I directed. Let the first the suit be presented.
Otherwise, where is the injunction?
Plain be presented. Then come with the GA.
Correct. Otherwise, there is no mother proceeding, my lord. How
because the mother is not there,
yes,
child is
how can the
moving.
child is, my lord, already moving?
Okay.
My lord, page 18, my lord, paragraph 20, my lord, has seen July 2020.
That is the one.
Yes. This is, my lord, the one I showed. Then,
That
my
is
lord,
the cause of action is they showing.
Correct.
With regard to the truth to the
21, 22. So they are aware, my lord, of what is happening.
Correct.
Then, my lord, kindly see, very important, 22. As no further notice was received from London mediation, petition instructed advocate check and update on whether any suit has been filed against the plaintiff. Upon inquiries made by the plaintiff's advocate, petitioner was made aware of an order dated 4th August 2024 of the Honorable High Court at Calcutta in AP 388 of 2024 and AP number 389 of 2024 filed by the defendants for setting aside for an arbitral award made in connection. So this is only the setting aside which got dismissed. I was successful there.
Yes.
Then upon perusal with the order dated 4th August 2024, this is all 2024, petitioner came to learn for the first time of arbitral proceedings initiated by the defendants connection with SPA. No, Lord, I don't know how much of my Lord, believe or disbelieve, my Lord, we should put in that. However, none of the parties to the arbitral tribunal gave notice thereof to the petitioner, in spite of being fully aware of the fact 18% total shares in Respondent 1 were assigned to the plaintiff. Now, my Lord, this is their agreement they're referring to. In this circumstance, the petitioner addressed an email dated 11th September 2024 to Respondent 2, 4, and 6, copy was annexed to Mark J. So, September 2024. Respondent 4 by its letter dated 18th September replied to the email dated 11th along with and forwarded a copy of an application. Now, my Lord, 25 my Lord, is Respondent 4. Similar to my friendly my Lord, respondent. Along with its forwarded a copy on application being APCOM 388 of 2024, copy of the plaint being CSCOM 764 of 2024. Contents of the letter dated 18 September were incorrect and denied. Copy was annexed to marks. Copy of the award dated 29 June 2020, which was annexed to AP, is annexed here to and marked as Annexure L. Copy of the print being CS 764. So they have everything.
Yes.
By September 2024.
Yes, they are having all that.
Yes. From the cost papers of CS, petitioner came to learn defendants falsely alleged the petitioner had not made full payment of the consideration for 18% shares. Petitioner states that although payments made by the petitioner respondent to have been admitted by defense, falsely alleged that the only respondents 4 and 6 have paid the full consideration in terms of SPA. Allegation made by defendant is false, incorrect, true and correct answer. Then my lord, kindly turn over. And my lord, 21, paragraph 28, they plead my lord fraud. And then my lord, page 22, again my lord, their cause of action, nothing my lord to do with my lord the urgency. Then my lord will straight kindly come to paragraph page 25. Now all this is arising my lord out of their original agreement. Kindly see page 25, paragraph 33. Petitioner has suffered loss and damages by reason of the defendant's failure and refusal to transfer 18% shares of respondent 1 to the petitioner stated hereinafter. Well, this 18% was under the 2012 agreement.
Yes.
Then, my lord, 34. Petitioner states that the purpose of acquiring the... And sorry, my lord, just to stop here for a moment, 33. By the award in September 2024, they are already aware that no transfer of shares. Now, money has to, my lord, be only, my lord, paid back to me. Then 34, petitioner states the purpose of acquiring the shares of respondent 1, exploit the leasehold right, respondent 1, said premises by constructing a new building thereat, shareholder respondent 1, earn profit. All this, my lord, is going on. Then, my lord, kindly come to, they, my lord, dream about this, they will make some money out of that. Then paragraph, page 26, paragraph, before paragraph 35, they say petitioner would have received at least 25 crore being its share of 18% revenue. I also did not get, now he wants 25% of the revenue and such. So then 35, these damages arise in natural course of things from the defendant's breach, knew and were aware. Then 36, in the premises, a sum of rupees, Malad says 51 crore Malad claim now they make. Then Malad, out of the refund of consideration is 26 crore. Damages, next page 27 is 25 crore. So that's Malad 51 crore. Then 37 is alternate inquiry loss and damages. Then 38, now they come and say the respondent 1 claims that it is already deposited rupees 26 crore 34 lakhs in court pursuant to orders passed by this honorable court. Now this was done in 2023.
Yes.
Pursuant to this honorable thereby discharges liability to repay the plaintiff. Petitioner is entitled to refund of the consideration paid by from the monies deposited in the honorable court and to appropriate the same in prudent to satisfaction claims in paragraph 32 above. However, the respondent is taking steps to withdraw this amount and has instituted EC 424 of 2024 for such purpose. Petitioner entitled to claims pursuant to registration defendant withdrawing any amount deposited registered on original side pursuant to orders made in AP 60 without making payments and such. Then that's how it comes. 28 invading and then the suit comes.
So this is the ground.
Yes.
However,
I have two submissions.
The respondent number 2 is taking steps to withdraw the amount and has instituted a EC for such purpose. It is entitled to and claims perpetual injunction restraining it. Yes. Then 39.
I have two submissions. His cause of action is not my EC. His cause of action is, my lord,
the award. 20.
And which admittedly
award is June
2023. And admittedly, assuming, my lord, let us, my lord, assume my case is that they all together in collusion, they really wanted me to stop from getting any money. But that is, my lord, my case. That is, my lord, different. Now, going by his averments in the plaint, that is, my lord, in September 2024.
Yes.
He's got a copy of the suit. He's got a copy of the award. He's got a copy of the setting aside application. And the order where I've succeeded.
Yes.
So with that cause of action, to now come and say that my urgency has come only because
you filed the EC.
Yes. And EC also, my lord, here I don't know, my lord, in the plaint, I am not sure, my lord, in the plaint whether they, my lord, said anything else. Then, my lord, kindly see, my lord, they come to, my lord, paragraph, page 29, paragraph 40, after, my lord, they set out the prayers.
Received a letter, 25th.
Yes. So how they build up this cause? Because respondent 1, my lord, is friendly. He is with them. As stated here and above, on 12th May 2025, petitioner has received a letter from respondent 1 purporting to inform that has refunded the entire amount received by it from the petitioner form of deposit made in this honorable court, that it owed no further liability to the petitioner. Respondent 1 is liable to the petitioner notwithstanding the deposit made by it in honorable court concerned letter to 12th May. Admittedly, petitioner made payment of aggregate and such, petitioner will refund of such. So this is Malad a cause of action which Malad the urgency is created by them, saying Malad the respondent 1, who's Malad the award debtor, all of a sudden, though Malad he's instituted a suit, 2024 Malad he's instituted a suit where he says the award is binding on them, where he also says registrar should refund part of the amount. He's filed a suit, but all of a sudden on 12th May, according to them, he also writes a letter to him saying that, look, I have given now all the money.
Where is that letter notice from? In this
It's Malad not annexed. Now, Malad, absolutely, Malad, going by their plain averments, cause of action, Malad, is going by whatever they have said to be correct, is Malad in September 2024. This is Malad a self-created urgency or cause of action, Malad, cannot be a ground to come and ask Malad for in a commercial suit, to ask Malad for this kind of leave. And secondly, Malad, I say, Malad, on the facts of it, absolutely malafide suit.
Okay.
Because 12-way leave, Malad, is also a question of Malad coming genuine into court to plead a genuine urgency, not Malad a dressed up urgency, to obtain an order, Malad, from court.
Yes.
So, Malad, on those grounds, Malad, I want to show Malad the judgments. I think, Malad, that is so far as Malad the 12A is concerned. So I think, Malad, if I show I'm more worried about Malad my other matter.
3 PM matter भी है ना?
हाँ?
3 PM.
अरे matter fix है.
वही उसी किसी कब रखिएगा. Let this matter come on Thursday at 3 PM.
Yes.
Mr. Thakkar, you are free.
You can give me the citations, then I'll
Yes,
come
no.
ready to deal with them on the next day.
Sir, Thakkar knows everything. Yes, of course, Malad will give him this. Copy did each other.
But I find master in drafting.
Mr. Thakkar, Malad, he's master in everything.
Lordship is.
Malad, I've seen him, Malad, really.
I have learned at the knees of Mr. Banerjee.
Malad, we have actually worked, Malad, he's worked with me, Malad, several matters.
Master in drafting. But leaving aside the argument and all, but draft.
He is. Malad, when then we used to Malad, do a lot of Admiralty matters together, Malad.
I've learned at the knees of Mr. Banerjee.
Mr. Thakkar used to come with his paint. I said, no, don't do this again. Again, Malad, he'll come back, Malad. Finish it, Malad.
To get planes drafted overnight, Malad, because the vessels would leave in the morning.
Right.
Overnight. Instructions would come at 8 o'clock. Plane is ready by 10:30. Mr. Banerjee settles it by 11:30. Suitors move next day. Vessel arrested.
That we have done, Malad, several. Those were, Malad, really we enjoyed us.
Yes. Now, kindly give us a time, please. Thursday, your lordship is.
At the 3 PM?
2 PM, Malad, that
2 PM, the other matter.
that will take some time, Malad. Kindly keep this in the morning, Malad. That 2 PM, this will take some time.
12:30 fix আছে আমার কাছে
So, shock.
না না সকালেই তো 12:30
12:30, 10:30. 3 PM হবে না, ওই পুন্না লুটটা চলবে।
His matter also.
Piramal, his matter. He is the plaintiff.
Acha, that matter.
Piramal is fixed at 3 PM
2 PM.
2 PM.
That will continue till at least
3:30 করো 4টে
3:30. 3:30, Malad.
3:30.
3:30. Kindly keep it at 3:30.
3:45 other matter is there.
Beg your pardon?
3:45 other matter is there.
Piramal will continue, my lord. We are resisting an injunction there, my lord. So that will take some time. Kindly keep it in the morning if it commences, my lord, because after this GA1 is also required to be here. Then they have a GA3.
This will take time.
GA3 চলছে
And this is 3, then there's GA2, section 8. Then my GA1. So, my lord, I'm in the queue since May.
Malad, he's been in the queue since Malad 2012.
I'll show, my lord.
13 years, Malad, let him wait for a little bit.
I'll show, my lord, since when.
Landed counsel for the defendant.
If to the 3, then, my lord,
has
come back.
argued the matter at length in connection with GA2. GA2.
GA3, Malad.
GA3. GA3 of 2025. But due to paucity of time, hearing could not be completed. Let the matter appear Let us see, I am fixing 3
3 p.m. Kindly keep
If
it.
time permit, then we'll
Yes, yes. Grateful.
the matter appear on
Yeah,
24th
Yeah, ठीक है.
July at 3 p.m.
I'm grateful.
Grateful, man.
Out of judgment, definitely. Let's bring it up. Look at it. My lord, this I'm so sorry, my lord. I'm troubling, my lord. It's a very, my lord, may I say, my lord, interesting and, my lord, I'm quite happy, my lord, to be in this kind of matter and, my lord, argue it before my lord. I'll tell my lord what's happened. My lord, I am a cargo owner. My lord, I entered into, my lord, a charter party. My lord, these are, my lord, done, my lord, by no, my lord, knows fiction notes. This is a white charter party. The defendant number 2 in the suit is the disponent owner, which means, my lord, the bareboat charterer. My lord, this is a voyage, my lord, in which, my lord, the cargo gets damaged. Quite naturally, my lord, in the suit, my lord, I'm the plaintiff, and, my lord, there is owners and parties interested in the vessel. That is, my lord, 1. And 2, my lord, is the disponent owner, my lord, who's also made a party. I arrest the vessel. Then, my lord, there's a correspondence, and, my lord, everything is on record, by the defendant number 2, who says, you should have really spoken to us before you arrested our vessel. There's a correspondence in August, my lord, of 2024. August 6, 2024. Then, my lord, defendant number 1, who's really, my lord, the head owner, comes in. 1 includes, my lord, everyone. Head owner comes in and yes, they say, yes, please release the vessel. Yes, you have suffered damage, correct?
We'll pay them.
Then, my lord, they get hold of a buyer who would buy, my lord, the cargo at, my lord, a reduced price. And they also make payment to me directly. So, my lord, my loss is taken care of.
So the cargo was uploaded.
Yes, cargo was shipped.
Okay.
I am the cargo owner. Cargo, my lord, undertakes this voyage.
Correct.
When it comes to Calcutta, we find, my lord, the cargo is damaged. So, therefore, I arrested the vessel. Then, my lord, they come and settle the matter. And, my lord, there's a settlement by which, that's what I said, my lord, there's a settlement by which part of the cargo is sold to, my lord, someone else where I get the money. I'm also given, my lord, money directly to, my lord, take care of my losses. There's the terms of settlement, my lord, which is signed between the parties, saying that this is the full and final settlement of all our claims, and also clauses. I'll show, my lord, clause 8 and clause 9, I think, my lord, where they say they will also have no claim against me. My lord, after, my lord, this is in August 2024. Then, my lord, finally the decree is passed. After, my lord, money is paid to me by 9th September 2024, decree is passed. Now, my lord, what they do this year is 2, my lord, who's really, my lord, the disponent owner, the bareboat charterer, sends a notice to me saying that the head owner has instituted proceedings against him to recover this money which was paid to me. And, my lord, they say arbitration, sorry, dispute between me and him, arbitration is happening, and he has started an arbitration against me.
You are the party?
Yes, between him and me. Now, my lord, on the basis of, my lord, that fiction note.
Fiction note, okay.
Fiction note, my lord, recalls, my lord, that white charter party, my lord, which was there. So, on the basis of that, he starts arbitration, my lord, in London, my lord, against me.
So how this fiction note will be taken into consideration?
Yes, it's already over.
That's why.
Absolutely.
That was complete.
Correct. That's so, my lord, we write to them and saying, sorry, I don't know what you're talking about, in the sense there's already res judicata, there's already a decree which is binding us. 2, the fiction note is gone because the fiction note now merges in the decree.
Not challenge that.
Not challenge. Consent decree. Consent decree. And I'll show, my lord, the terms of the decree as well. On this basis, my lord, the institute, my lord, we have filed, my lord,
so now what
examine this.
File?
My lord, we have filed, my lord, because 2 things we could have done. Either, my lord, a suit to have, my lord, an anti-suit injunction, or, my lord, we found that, my lord, in the decree itself, it says they will have no other claim against me.
Correct.
So I filed an execution
for what?
On my decree in the Admiralty suit to say, my lord, they should not proceed with that. Because A, my lord, it is in violation of the decree. Because the decree says so, my lord, all claims are over. So I filed a execution with an order of injunction saying you cannot proceed.
So what?
Yes, my lord, may I Because Malad knows I'll show Malad the judgments, Malad remembers Malad Modi Entertainment, which Malad talks about anti-suit injunction, anti-arbitration injunction.
Yes.
And Malad, we also have another of our judgments, Malad, division bench presided over Malad by Justice Shonji Banerjee, Malad, where he examines these principles and says, yes, it is possible.
That's the thing only. That is the only point.
That is the only. And it's very interesting because Malad, this now branch Malad has really Malad, because so many of these Malad suits are filed where Malad they breach agreements.
Because why they want? Because settlement. Once it,
Malad, kindly just have Malad, I want to show Malad, first Malad is the settlement terms, which Malad will find. Sorry, Malad, may I just, I'll try and Malad make it. First, Malad, fiction note is at 21 to 25.
21 to 25.
Yes. This is important only, Malad, to note the date. At the top, Malad will find arbitration notice.
Yes.
Malad, kindly note the date, Malad, 26 June 2024. At the top of page 21.
Yes, 26 June 24.
And Malad, arbitration clause, Malad, is at page 24. Malad will find
24.
Yes, Malad, page 24, clause 27. GA and arbitration, that's Malad, general average and arbitration in London. And English law to apply. In case of any disagreement, matter said amicably arbitration London, English law to apply. Clause 27.
Yes, got it.
Next, show me the settlement. Next. Malad, next, kindly come to Malad, page 26 and at Malad, page 29, where Malad, we file the suit.
Yes. This should decree.
Yes, Malad, kindly see Malad, the party, owners and parties interested in vessel MV Sunsach, Dave PT Limited, Malad, that's 2. And I just want to show one paragraph, Malad, in the suit. At paragraph 4, page 30. Plaintiff states that during the course of business, plaintiff has entered into a charter party with defendant number 2 in confirmation with the owners of defendant number 1 vessel, and a fiction note was executed on June 26. That's what I showed between the defendant number 2 and the plaintiff. We had mentioned head owner being the owner of the defendant 1 was mentioned as a fiction note. Fiction note makes it clear the defendant 2 has authorized and competent represent the owners of defendant vessel, transferred such and such. Then, Malad, I complain of damages. Malad will find para 6, Malad, it was the goods were loaded in Indonesia. Then, Malad, kindly come to page 38, paragraph 23.
Claim.
Yes, in the aforesaid circumstances, plaintiff is entitled to payment of towards value of damaged cargo for an amount of rupees 7 crore 8048 77480 Sansar. Commercial transaction Sansar. Then, Malad, arrest order, Malad, is there. I don't think, Malad, that's Malad at page 43. Arrest of the vessel. Then, Malad, kindly come to Malad, in this, Malad, we have just made a bunch of Malad, all the orders, all Malad, one after the other, Malad, that will correct. So, Malad, kindly look at Malad, August 4. Page 3, Malad, will find the narration of facts. Then page 5. Second last paragraph. In the aforesaid facts and sum, there should be an order directing arrest of the vessel. Marshal of the court directed to forthwith arrest. Then, Malad, page 6, Malad, will continue arrest and all that. Then, Malad, kindly come to page 9. enhancements, we can ignore that, my lord. Kindly come to page 11. This is 29th August 2024.
Agreed passed accordingly.
Learned counsel for the parties contend that a settlement has been arrived at between the parties. Terms of such settlement writing filed in court today, we kept on record, made a part of this order. If leave is granted, file Vakatnama, parties submit, agreed order be passed. According to following order is passed. Then number 12, administrative taken up our turn mentioning of the parties. Learned advocate served notice of proceedings for being taken up. Present terms are executed. Original kept on record of the suit. Vessel is permitted to be shifted to Authority Shyama Prasad Mukherjee Port to hold the anchorage, but to remain there until fulfillment of the agreement constant terms of settlement. Vessel shall, until further orders, remain with the territorial waters and such. Then, my lord, to be listed on 9th September. Then, my lord, sees 9th September, page 13.
Yes.
Learned counsel for the parties submit that the parties have complied with the terms of settlement between themselves. Accordingly, the vessel is hereby directed to be released immediately to be acting on a server copy of this order, Marshal Son. Then all parties to act on a such. Then on next page 14. In view of the above, ASCOM 4 of 2024 stands decreed by consent and disposed of on the aforesaid terms of settlement and receipt of payment. All interim application orders passed in. So, my decree is passed. Now, my lord, kindly come back, my lord, to the main application. And, my lord, kindly see the settlement.
Where is the settlement?
Sorry, my lord.
Where is the settlement?
Settlement, my lord, is at page 10123. One, two, five, my lord, it starts.
Yes. Yes.
And, my lord, kindly look at 126, subpara 2. Defendants, vessel owners have identified Selpap Mercantile Limited Liability represented by its designated partner, JKD, also its CFO, Sunsets, for purchase of the 1330 metric tons of cargo damaged. As per pleading held on Sunsets. The defendant vessel arranged such transaction, then, my lord, 127. Towards purchase of the damaged 1330 metric tons cargo forming relevant subject matter of suit, Selpap Mercantile shall directly pay to the plaintiff a sum of rupees 6 crore 51.
Directly paid to the plaintiff is of 6 crore 51,70,000 without any adjustment or deduction whatsoever.
First element, then, my lord, kindly turn over 128. Subparagraph 4. Owners of the defendant one vessel shall be responsible for compliance to Selpap Mercantile in the above resolve and will resolve any issue that may arise in implementing these terms in respect of Selpap Mercantile. Parties understand damaged cargo is otherwise a total loss to the plaintiff. Amount to be paid by Selpap. Terms and shall continue to remain maritime claim against the vessel, liability of defendant owners until received by the plaintiff in entirety as per these terms. Then, my lord, 129. Then, my lord, 129, subparagraph 6.
In addition to the independent.
In addition to an independent by the aforesaid payment to be made by Selpap, purchase of the damaged cargo, the owners of the defendant one vessel through the agents in India, namely GAC Shipping India, Private Limited, having its registered office at Sunsach, Willingdon, Cochin, shall directly pay to the plaintiff 2 crore 24 lakhs.
Further. This is other than the 6 crore.
Yes, because the cargo was worth, Malad will recall, Malad, the cargo was worth 8 or 9 crores, Malad, in the plaint. That was the claim.
Directly paid.
An equivalent amount of 1 crore 88 within 5 days from working. So, Malad, damaged cargo bought by Selpap, I am paid 6 crore 51 directly, and I am paid additionally 1 crore 88 by the owners.
No,
now,
directly paid. Cochin shall directly pay the plaintiff at the bank account of 2 crore 24.
Sorry, Malad, US dollar 224, which is 1 crore 88.
1 crore 88, yes.
Now, Malad, see 7. Very important. Subpara 7, Malad, at page 130.
Yes.
Plaintiff's entire claim in the instant Admiralty suit shall stand satisfied, settled, and fulfilled, with the plaintiff receiving the aggregate amount of US dollar 224 corresponding to INR 188 and INR 651. Upon complete and satisfactory receipt of the aforesaid sums in the bank account specified in these terms, plaintiff shall have no cause of action or maritime claim surviving against the vessel MV Gyang Ming or her owners, the captain and crew, operator, manager, protection and indemnity insurers, any other person or company related to the said vessel or transportation, nor will the plaintiffs file any other claim or take any preservation measures against the sister ships belonging to the said owner or manager of the vessel. Plaintiff's maritime claim against the vessel and the owner shall subsist, remain actionable, however, until complete payment of the aggregate settlement sum is received according to these terms. Now, can I see 8? Likewise,
the owner of the defendant,
owners of the defendant vessel or her charterers, captain and crew operators, managers, agents, P&I, club, bareboat charterers, which is 2. Disponent owner, again 2, or any party interested in said vessel shall not have any claim or cause of action or grievance against the plaintiff in any jurisdiction of the world. Because they had entered appearance here. So they're bound by our jurisdiction.
Yes.
Messrs. Selpap, then 9 is not relevant. Then kindly see paragraph 2 at 132. A shall stand decreed by consent disposed on the aforesaid terms upon receipt of payment of aggregate settlement amount by the plaintiff. Then all interim orders. Now we receive payment, that is recorded in 9th September and decree is passed. Now what they do?
What is the letter? Where is the letter?
Yes. Now kindly come to page 145, which is in the second.
Yes.
This one. Yes. Well, kindly first come to page 145.
Yes.
145 the first one. 145.
Yes.
Sees.
Who is sending this? CBS.
Yes. Yes. Sees at the bottom we have received below email from the disponent owners based in Singapore.
No, who has sent this?
This has been sent. This chartering king.
Yes.
Yes.
CBPL.
Yes. To us. I am Imami.
To Devaprata Imami.
Yes. Huh? And then sees Dawa PT Limited Singapore in the middle. Will find.
Copy 2.
That's D2. Who's the disponent owner? Bareboat charterer.
Dawa P2. Where is that?
In the middle, where it says we have received below email from the disponent owner based in Singapore. In the middle, of page 145.
Yes. Dawa P2.
Yes.
He has sent.
Yes. Please pass following to charterers email Paper Mill Limited and confirm. Quote. We refer to the sees.
Chartered party.
Yes, 26 June 2024.
That one.
Same one. Evidence by way of recap and incorporate in terms of a GenCon. As you are aware, on 4th August, the High Court Calcutta made an order for arrest of the vessel. It was charterers in the capacity as cargo receivers under the relevant bills who made the application to arrest. Basis of the arrest was a claim for alleged damage sustained in cargo of hardwood pulp. Owners understand that charterers cargo settled the claim directly with head owners. Owners have since received notice of a claim from head owners who have threatened to commence arbitration proceedings against owners under the head charter party. For your information, head owners' claim against the owners comprises the following. Now let's see the principal sum, that same amount which was paid directly. Now they claim from head owners. Now claim from. So 1 and 2 have this little arbitration which they say they have started claiming this 224. Then cost of transporting cargo to buyers. All this claim is made. Then we immediately reply.
So for that incur the cost of census and so owner the rights. So what they pray for? What
they say next page 146. Owners hereby put charterers on notice.
Correct.
That owners will seek to recover their loss in relation to the incident.
Correct.
Including but not limited to any liability to the head owners as set out above, as well as owners' own incurred loss from charterers in due course. I will show subsequent letters where they have started arbitration with me. Liability for this incident rests with charterers pursuant to clause 5A of the GenCon, where the cargo claim and resultant arrest arose from inadequacy, insufficient package of the hardwood pulp. Where is all this scope now available? Barred by res judicata. Admission, decree where you admit.
Security demand.
Cargo was stored, security demand security from owner in respect of 1.2 million. Please confirm that charterers will provide counter security sum of US 1.2 million with next 14 days, all owners and such. Then, my lord, we reply. I'll just show a few paragraphs of that, my lord, and then I'll come to, my lord, the main letter. Kindly come to, my lord, at page 149. My lord, it starts, my lord, at the bottom. My lord, we'll find at the bottom, my lord, 30th April, we reply, Devendra Banthia, which is Imami paper, my lord, that's the plaintiff, to, my lord, Charter King, my lord, who had sent this to us. And then, my lord, will kindly come to 149 at the bottom. Last paragraph, subparagraph 10, pursuant to such arrest, a neutral joint survey was carried out.
Where?
Sorry, my lord, page 149. At the bottom of that, my lord, this is part of our email.
Pursuant to such arrest.
Yes, pursuant to such arrest. Neutral joint survey was carried out by independent survey of Haldia being the port of discharge to approximately assess the nature and extent of cargo is damaged. Upon such independent survey, it's found that approximately 1330 was rendered complete damage, spoiled, and almost unmerchantable. Based on mutually agreed upon terms of settlement, which were drawn up and acted upon between the adversary parties, our company as the cargo receiver, the head owners wages to one Selpat, mutual reside in Sansach, auspicious Honorable High Court, received approximately 5.93 and about damaged cargo Sansach. So, my lord, I say this, and then, my lord, will kindly come to page 150. Kindly see, my lord, Roman 17.
Yes.
At page 150. Most significantly, damaged condition of cargo was a prime issue in Admiralty suit number 4 of 2024, which was brought before the Honorable High Court at Calcutta. No allegation remotely suggesting that there was any inadequacy or insufficiency with regard to packaging of the cargo was established at court proceedings. Again, cost of repetition, we reiterate, storage of the cargo never responsibly, never undertaking such tasks and such aware of the position. Yes. So, my lord, this is, my lord, where we, my lord, go, and then kindly come to page, my lord, 152.
Jack Redroof.
Yes. My lord, this, my lord, now they instruct, my lord, lawyers. And kindly similar, dear such and such, we are instructed by Dave PT, owners in relation to White Charter Body, dated 26 June. Evidence by way of recap incorporating terms. Refer to your other such and such. My lord, can skip over all this and kindly see at 153.
You are not prepared to engage with the contractual terms of CP. Say agreed lodging.
Then the next third line, please confirm by close of business. Instructed lawyers to accept service of a notice of arbitration.
Yes.
Then, my lord, kindly come to page 1. Where's our main letter? 160. Sorry, my lord, 159. This is, my lord, our reply. And kindly see in the middle, my lord, suit was subsequently disposed of.
Yes.
Suit was subsequently disposed of by the parties on a decree based on settlement terms achieved between yourself and the vessel owners, were also admitted by this honorable court, being satisfied and such. Then, pursuant to the decree, my lord, we set out clause 8, 7, and 8,
yes,
which, my lord, I have also read to my lord in terms of settlement. Then, therefore, we say with this, with legal guidance, all issues and attributes of the parties under fiction note dated June 26 came to an end with termination of the Admiralty subject to application. And what fell from, my lord, the court, my lord, saying that what is surviving. That's exactly what we say. Dave PT, being a party specifically arraigned in Admiralty suit, is bound by the decree of the Honorable High Court, Calcutta. Then dispose of the above mentioned Admiralty suit by the final consent decree is tantamount to final adjudication of all disputes in suit, an integral issue whereof was the fiction note dated June 26. Any claim sought to be included in the guise of further proceedings clearly will be barred by settled and universally recognized principle of res judicata, as also independent of the doctrine of issue of estoppel between the parties to the suit. the nature of financial demand cannot be re-agitated as against us being the plaintiff in the Admiralty suit, notwithstanding in fact demand has been in the sheer conjecture, presumption not based on real circumstances. Presume head owners and exchange correspondence. Then, my lord, 160. Kindly look at, my lord, the third line. The High Court at Calcutta retains jurisdiction through its enforceable decree passed in AS in all matters relating to alleged fiction note dated 26 June 2024. Then, my lord, we also tell them it will be contempt, which is also correct, my lord. Even if it's a consent decree, my lord knows that can also be a contempt. So, any breach or contravention of any of the conditions of the decree passed by this Honorable High Court Calcutta construed as willful and deliberate act of contempt, solemn order of the High Court for which the parties found guilty, as well as the directors, person responsible for such. Then, my lord, we say all this. And then, my lord, what they do at 161.
Yes.
Notice of commencement of arbitration. Charter party dated, my lord, 26 June 2024. We are the instructed solicitors on behalf of English solicitors on behalf of Dave PT, relation to a dispute which has arisen between the owners and new Imami paper mills.
Okay.
The charterers of the MV Gyangming under void charter party dated 26 June 2024. Dated 26 June, evidence by way of a recap, incorporating terms of GenCon. Disputes have arisen between the parties relating to a result of claims made by the alleged damaged and such.
Yes.
And, my lord, page 162, my lord, they rely on the same clause 27.
160?
My lord, at page 162.
That is there.
Clause 27. My lord, I showed that, my lord, in the fiction note, my lord, will recall. And commencement of arbitration, my lord, sees at the bottom of that page. Owners hereby commence arbitration, respect and dispute and charter party, hereby notify appointment of such. And then please appoint charterers chosen arbitrator within 14 days. Please confirm. Appoint sole arbitrator should be fulfilled to here. Take steps to appoint such sole arbitrator in this matter.
What is the date of this letter?
My lord, this letter, my lord, is 1st July. Then, my lord, there is more correspondence after, my lord, we filed the suit also. This is, my lord, the rest of the correspondence, if my lord wants to have a look. Because again, we write back saying, sorry, it is all done. It is res judicata.
You file a suit? No.
Sorry, my lord. No, my lord, we filed this execution proceeding. Then, my lord, the last is, my lord, take it level.
So this is the 1st July.
So, and then, my lord, page 5, my lord, is 16 July.
Page 5 of the
Last one, my lord, page 5.
Yes.
Where, my lord, they say within 7 days we have to respond to.
Where is that?
My lord, the last page,
question.
6. To the extent that you message my intended service notice of charter's appointment of Mr. Anka Chan nominated Sanjay, defective, owners hereby give notice pursuant to section 17(1) that should charters fail to serve notice, they appoint an arbitrator in this reference within 7 days from the date of this notice. Owners who appoint Mr. Amos as sole arbitrator in reference with
So what
further
is the
notice.
date of this?
My lord, 16 July, my lord, at the page 5, my lord.
Tomorrow is the last date. 23rd is the last
Yes.
date.
Tomorrow, my lord, that's what I mentioned, my lord.
Yes.
So, my lord, this is, my lord, I've never, my lord, seen this kind of matter where, my lord, you submit to a decree. Decree says all claims gone. Charter party is, my lord, is gone now because it gets subsumed, my lord, by the decree. That's the principle of law.
So
And
with regard to only the arbitration against you.
yes. That's right. Whether, my lord, they have their own arbitration, I'm not bothered, not interested.
You continue.
Yes. But you can't file an arbitration against me in violation of, my lord, the order. My lord, I'll just, my lord, quickly, my lord, show, my lord, the division bench. On the law, my lord, can take it, my lord, from ask, my lord, that division bench. I have, my lord, got, my lord, several decisions, but I don't think, my lord, I should take so much time, my lord, trying to, my lord, Devi resources. Well, this is 2019. Yes. Well, 2019. 2019 SCC online. Calcutta 774.
Yes.
I'm just straight away trying to show the law. '49. At page internet 1749, can have a look, but I'll just straight away come to yes, 54. While it is impossible to imagine every possible ground that can be urged by a party to arrest the initiation or the continuation of a foreign arbitral reference, even by inviting an injunction in personam, there can be certain broad categories in which such grounds may be placed. There could be cases. There could be classes of cases challenging the jurisdiction of the foreign arbitral tribunal on the ground of the very existence of the arbitration agreement. Here, my lord, arbitration agreement doesn't exist because it's merged, my lord, with the decree. Existence of the arbitration agreement, or the efficacy of the arbitration agreement, or the survival of the arbitration agreement,
or the
jurisdiction of the arbitral tribunal. Likewise, an anti-arbitration injunction may be sought on the ground of the incapacity of the parties seeking the injunction on grounds of overwhelming inconvenience to such party. Another class of reasons invoked to seek an anti-arbitration injunction could be the egregious fraud committed by the party seeking to initiate or pursue the arbitral tribunal, or of the arbitral reference being patently vexatious or unbearably oppressive. In every case, it is the duty of the court to exercise extreme caution and circumspection, because before issuing an anti-suit or anti-arbitration injunction, and as such, and as high authorities instruct, the injunction should be in personam and issued against a party amenable to the jurisdictional court, issuing the injunction not against a foreign court or a foreign arbitral tribunal. That's why, my lord, quite naturally, we have made, my lord, parties, my lord, to the defendants.
What you have prayed for in this execution?
My lord, execution.
Because you have received the amount.
I have received them. I want the injunction for them not to proceed with the arbitration.
So that in the execution proceeding you can.
Yes, my lord, because
anti-suit you can.
Because, my lord, the terms of I can't, my lord, there's no anti-suit injunction, my lord, because, my lord, the terms of the decree says
closed.
That's right. That's why. Because that whole thing, my lord, is a decree now. My lord, if my lord looks at, my lord, the first.
Right. So only injunction in the where is your prayer?
My lord, prayer. My lord, kindly look at, my lord, prayer. First prayer, of course, my lord, is specific informant of clauses 8 and 9. 8, clause 8. And then, my lord, 2, 3, 4. Roman 2, Roman 3, Roman 4.
The prayer. Where is the prayer?
My lord, in the tabular statement, my lord. Tabular statement. There, my lord, we find, my lord, prayer. First prayer, my lord, is in the first on the first page, most probably, my lord, in column 10. That is specific execution asked for. Then, my lord, can you see Roman 2, Roman 3, and Roman 4?
Yes. Next.
So, my lord, because, my lord, otherwise, my lord, it will be in breach. I have, my lord, where, my lord, we claim anti-suit injunction. We come and say, my lord, perhaps that court has no jurisdiction, perhaps that court, the arbitral tribunal is in breach of some arbitration agreement here. Here, my lord, I have the highest case, where the decree passed by this honorable court, where you have come and submitted to a decree, with the decree saying, sorry, no cause of action exists. No claims whatsoever in any forum. So, my lord, just I was showing, my lord, paragraph 54 I have shown. My lord, with regard to my lord, paragraph 55 in the middle, court must be alive to the fact that even an injunction person such as interest functioning or sovereign formal business at the same time, despite in the middle, placing such an onerous burden on a court, assessing the propriety of such an injunction, authority of such a court, unless a very limited jurisdiction cannot be doubted, particularly if it is a high court in this country exercising its ordinary original civil jurisdiction.
Yes.
The very purpose then 56 law is to write law is to right a perceived wrong in course of a court writing such word wrong at times, sometimes more than adjudicating the immediate release is also called for. It will be futile for a court to proceed steadfastly towards the decree, or in the meantime, subject matter of decree is wasted. Kindly similar, this is important. Subject matter of decree is wasted or destroyed. And here, my lord, I have a decree. This is, my lord, in protection of the decree itself.
Okay.
My lord, and just, my lord, 62 suit may lie, my lord, that is also then 63, 64. This was, of course, my lord, in the case of a suit, where, my lord, the court also says, my lord. My lord, 65, I'm sorry, my lord, I'm just trying to, my lord, read as less as possible so that, my lord, I don't take 65 equally, last page, my lord, equally merely because injunction sought against a foreign court or a foreign forum and not in person against a party amenable to court. Season of prayer for such injunction, it would make the prayer for injunction infructuous. Application meets the high test otherwise required. Court may mold the relief and issue an injunction personam. Some of the judgments, including no evaluation, the anti-suit may issue personam only against the party amenable to jurisdiction court issuing the injunction. Seen or tested time of sentence may also be such amenability need not be seen or tested time of injunction, issuance of the injunction, but may also be seen from a different perspective. Such an injunction is sought against a foreign party or party amenable to the jurisdiction court. Amenable to a foreign party to such court may also be seen in context foreign party coming on a later date to enforce the foreign decree or foreign award in this country.
So, which period you are praying for now?
My lord, I am praying, my lord, for prayers. My lord, 2 and 3, my lord.
An order of injunction.
2, 3, 4 actually, my lord. I think, my lord, that
contained in the terms. It cannot be. An order of injunction restoring judgment after from taking steps. 1st July. 4.
Yes.
That's the
2 and 4, my lord. Or 3 and.
Good.
I was, my lord, respectfully something 2, 3 and 4, my lord, all 3. But, my lord, I leave it, my lord.
Okay, let me see.
And, my lord, Supreme Court also, my lord, I'm there, my lord. If, my lord, I'll just give the reference. Modi entertainment, my lord, will recall. I'll just give, my lord, the judgment on that, my lord. Where, my lord, there's several decisions. My lord, Modi entertainment, my lord, is also, this is 2003 4 Supreme Court cases 341. Paragraphs, my lord, 24 to 26. And 24 1B, my lord, will have a look.
If injunction is declined, the ends of justice would be defeated and justice would be defeated.
Because here, my lord, my whole decree will become infructuous.
Yes.
And, my lord, in the petition, my lord, all the necessary pleadings are there, my lord, with regard to, my lord, that I'll suffer. Going to sit out here. My lord, there are other judgments, my lord. I'll save it, my lord, for a better day, my lord, hopefully. Hopefully, my lord, we would have, my lord. My lord, I was praying, my lord, for those release, my lord. I'm so grateful, my lord, for taking up the matter, my lord.
Thank you. December में
আমি already apologize করেছি. My lord, my learned junior saying whether my lord you should apologize for yesterday. I said I will come and apologize the first thing.
Thank you.
I'm so grateful. My lord, I thought my lord is going to take my lord the other matters at 2 o'clock. So my lord, I went off my lord for a
Okay.
arbitration. Grateful. Thank you, sir.
Yes, next.
Sorry. I'm like,
Yes, 3 p.m. What will happen?
English.
You have 10 minutes.
Oh.
Witness or hearing? Hearing.
Mine is a suit hearing.
Witness. Date fix. अभी 3 बजे क्यों फिक्स है? 3 बजे फिक्स मैटर कौन सा है? हाँ, ये कौन सा है? Okay. Yes.
My lord, item number 73, my lord. We are paying for time, my lord.
Record and order. Item number 73. The matter is specially fixed. Who is for the defendant?
My lord, friend is.
The matter is specially fixed today for witness action, but the counsel for the plaintiff press for time. According case is adjourned. Let the matter appear on 2nd September at 3 p.m.
As per the earlier direction, my lord, I have not received the judge's brief of document.
Sir, my lord, actually they have filed the judge's brief. Defendant has filed judge's brief of document, my lord, including all the.
Give whatever it is. Give it. Call the next one.
My lord.
So the copy on the next. Otherwise, you impose the cost on the next date. If you make a submission that it was not served to you.
Actually,
serve it. Yes, next. Yes.
Yes, sir. Huh? Nominated. Oh, no, no. Yes. May I please your lordship? I am the plaintiff in the suit. So before I take your lordship through the
It will
play,
take time.
it will take some time.
What application you have filed?
No, it's a suit. The suit is ready for
Argument.
hearing for argument, final arguments.
Okay. Who is for the defendant?
The defendant, Mr. Huda, was appearing. Then, if your
I
lordship,
know of appearing for the defendant.
Yes.
Item number 72. My lord, I'm praying for accommodation for filing wakalatnama. There has been sudden change of brief, so I've been instructed by the defendant to pray for a short adjournment.
in earlier matter also, there are two suits. In other suit also, on the last occasion, they appeared and wanted to file a wakalatnama change. I don't know whether they have filed. They are taking steps because if your lordship takes the conduct of the defendant, I'm not saying anything about the advocate. Their only purpose is to delay the hearing of both the suits. So this suit is ready for hearing. I am ready.
Okay, you can. I will see that. What is the suit for?
Yes, the suit is for recovery of the money. I'll tell your lordship. There are two plaintiffs. Both the plaintiffs are from the same group, that is Karanchand Thapar group. The plaintiff number 1, Indian City Properties Limited, is the owner of a property situated at 163 SP Mukherjee Road, known as Thapar House. And the plaintiff number 2 is a company which provides services of management to the occupiers there. So in this property, sometime in 2017, the defendant Reliance Commercial Finance Limited approached for spaces for their offices. After negotiations, they have taken 3 floors. Out of those 3 floors, a total area of around 6,640 square feet odd was given to them on lease. The lease was of 2018. Rental was being paid, and there was another aspect apart from the lease rental was the services which are provided by the plaintiff number 2. They used to pay those service charges. Now the issue started when the COVID hit. Because of the pandemic, from January to May, obviously there was official notifications of the lockdown and all. The defendant is a NBFC, non-banking financial company. So we wrote to them that you have to have limited employees as per the government rules and let us know when will you function. So of May 22, 2020, they said, yes, on May 22, 2020, we will start functioning. Thereafter,
they have stopped March 20.
during March, the lockdown started, and by May, it was phase-wise, it was relaxed. And being an NBFC, they were in the first category of getting the relaxation. Thereafter, they said, no, we will terminate this contract. In the lease, there is a specific clause for lock-in period, that if you terminate during the lock-in period, then you have to pay for the rest of the time of the residue period of the lock-in period. Without paying that entire amount, you cannot go. You may terminate. Their stand is, it's a vague stand in the written statement, though none of the defendants have come forward to prove their evidence or the written statement. Their stand is that, no, it was a force majeure clause which we are invoking. Because of the force majeure situation, I am not entitled to pay you anything. Despite from January, the payments are due. So I have different heads of claim under which this suit has been filed. And I am supported by judgments also that even during pandemic, being an NBFC, they cannot take the advantage of the pandemic as a force majeure for not making a payment in a commercial transaction. So this is the whole and sum of the entire suit. There are two suits. So because of the two companies, so another suit as and when it comes. So may I take a lot?
What is the stage of that suit?
That suit, the evidence is just completed by the commissioner. The commissioner will file the report on 30th of this month. So that suit is also ready. That is undefended completely. And here the defendants were appearing. That is completely undefended. Here the defendants were appearing.
Different.
Yes, it's same. One is Reliance Commercial Finance Limited, another is Reliance Home Finance Limited. Same group. Same group. It's just the name change. So may I take your lordship to the plain first?
What are the issues framed?
Yes, the lordship will take the order of I'll just order of 5th January 2023, when your lordship was pleased to frame the 11 issues in the suit. 5th January 2023. Whether the suit is maintainable in its present form, whether the lease dated 2nd November 2018 and the service agreement dated 10 January 2018 could be terminated by the defendant, whether adequate notice of termination of the lease and service agreement was issued to the plaintiff, whether defendant vacated the suit property immediately after the alleged termination on 30th May 2020 and handed over the possession of the suit property, whether the defendant was in wrongful possession of the suit property from 30th May 2020 till 5th October 2020, that is the date of handing over of the suit property, whether defendant is liable to pay any amount to the plaintiff, whether the plaintiff is entitled to receive the amount of 89,57,896 or any part thereof as more fully detailed in paragraph 23 of the plaint, whether the plaintiff is entitled to receive the amount of rupees 128,46,947 or any part thereof as detailed in paragraph 28 of the plaint, whether the plaintiff is entitled to interest component of 12% or any part thereof, whether the plaintiff was required to carry out fit-out installation as a precondition of the lease, whether the defendant is entitled to cost. So these were the issues which were framed. So may I take your lordship through the plaint? In the plaint, it has been narrated as to how the entire transaction has been carried out.
Yes.
Lordship. The plaintiff number 1 is engaged in the business of inter alia leasing out commercial properties in Kolkata and all over India. And the plaintiff number 2 is engaged in the business of providing facility management services to diverse commercial properties. The plaintiff numbers 1 and 2 belong to the same group of companies, namely Karamchand Thapar Group, and have their registered office at Thapar House, 25 Brabourne Road. Plaintiff number 1 is the owner of the premises 163 Shama Prasad Mukherjee Road, Kolkata 26, and the building standing thereat known as Thapar House, situated outside this jurisdiction. Defendant has its registered office in Mumbai and outside the jurisdiction also carries on business from its regional office at 9B Wood Street, 4th floor, Kolkata, within the jurisdiction. Sometime in or about 2017, the defendant approached the plaintiff number 1 for taking a commercial lease for the purpose of carrying out its trade and or commerce in Kolkata, and discussions were held between the parties. The plaintiffs offered inspection of a portion of the office space available at Thapar House at 163 SP Mukherjee Road, and same was inspected by the defendant.
They have adduced the evidence?
No, they were adducing before the commissioner. After the plaintiff's 2 witnesses' evidence was over, they were adducing. In the middle of that, when the cross examination was about to start, the witness said that I have fallen down and I will not appear any further, or rather, I have gone to Mumbai. I can't appear in commission. The commissioner wrote to him that you tell me you are in Calcutta, you are injured, you can't come. I'll go to you. So he said, no, I have traveled to Mumbai. Then this matter was pointed out before your lordship, and your lordship has closed their evidence on May 7, 2025. Recording their conduct and everything, their evidence was closed.
They are not challenging that order.
No. That order is not challenged. It is only after this a new set of advocates are appearing saying we have taken change and we will file wakalat now, but nothing has been done. May I come back from paragraph 5. The defendant represented that it required some special fit-outs and equipments installed in the premises before the commencement of the proposed lease, and it was agreed between the parties that the plaintiff number 2 would provide the required fit-outs and equipment and also all necessary service to the defendant for the said office space, and the plaintiff number 1 would execute a lease in favor of the defendant. Accordingly, plaintiff number 1 entered into an agreement on January 10, 2018 with the defendant for leasing out the office space at Thapar House at 163 SP Mukherjee Road, measuring 6644 square feet, situated on the 3rd, 5th and 6th floor of the said building. He then after referred to the said premise. Paragraph 7. As agreed, the plaintiff number 2 and the defendant entered into an agreement dated January 10, 2018, being the services agreement for facilities, amenities and fit-outs. All these fit-outs which are being made by the plaintiff number 2, those are customized as per the requirement of the occupier. So it's not that something I can use it or give it to someone else or a new occupier who comes. The said service agreement dated 10 January 2018 provided inter alia as follows.
So let me stop here.
Lordship. Oh, no.
Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. Yes, Miss Purba Biswas, an advocate appearing for the defendant, submits that she has instruction to appear in the matter and she prays for leave to file wakalatnama in the department on behalf of the defendant. In view of the submission made by the counsel for the defendant, leave is granted to the advocate to file wakalatnama on behalf of the defendant within a week from date. Let the matter appear on 14th August at
14th August, your lordship, I might be in some difficulty. Prior to that or immediately after that independence holiday.
18th August
Lordship.
At 11:30.
Lordship. Deeply.
File wakalatnama, madam, you and come on 18.
Chocolates.
May it please the lordship.
Yeah. Undefendant?
Yes, my lord. My lord, I appear for the plaintiff in this matter. My lord's evidence is completed. Your lordship had fixed it for hearing, my lord.
Jalnidhi bitumen. How the bitumen can be Jalnidhi? Then it is not.
I've ordered. My
It
lord,
will not
name-
work. The bitumen with
Precisely. That's the dichotomy, my lord, as indicated by lordship.
Yes.
My lord, the plaintiff is a company engaged in the business of manufacturing and supply of bitumen emulsion, along with integrating material along with technology for resolution of road repair. So basically, it's a road construction and the raw materials that are provided, ancillary products, it produces all of that and supplies it. The defendant, on the other hand, is engaged in the business of microsurfacing of roads. So when the roads are scraped off, my lords, there's a tender that is issued usually by government authorities to microsurface the road so that it is again leveled. So my lords, my lords, sometime in June 2019, the defendant, who is also the sole proprietorship firm, approached the plaintiff for supply of bitumen emulsion. It was understood, so my lords, this understanding was arrived at while at the principal office of the plaintiff company which is within your lordship's jurisdiction. This, my lord, has been indicated at page 3 of para 2 of the plaint, my lords. Para 2, page 3 of the plaint, wherein I've indicated that the registered office of the plaintiff company, my lords, that is within the original site jurisdiction, my lords. Accordingly, I've approached this honorable court, my lords.
Yes.
So it is understood between the parties that from time to time, the defendant would place verbal orders upon the plaintiff, and the plaintiff would supply such goods at the designated location that is indicated by the defendant. It was agreed between the parties that payment would be made within 15 days of raising of the invoices, failing which interest of 18% per annum would be attracted. This, my lords, would also be evident from the invoices that are raised that I'll take your lordship through, my lords. So on the basis of such representations that were made by the defendant, and assuming the defendant to be a bona fide purchaser for price value of money, the plaintiff proceeded and supplied the requisite goods from time to time as had been placed upon, as had been demanded by the defendant through the plaintiff, my lords. Also, my lords, an MOU was entered into sometime in February 2020 by the plaintiff with a third party, just for the sole purpose of supplying slurry machine. There is the same, it's a part of construction, my lords. So I have raised bills upon them. They have, in admission to such bills, made part payment to the tune of rupees 15 lakhs in 2021, my lords. So today, my lords, all that I'm saying is that I am entitled to a sum of rupees 2 crore 20 odd lakhs in terms of the invoices that I've raised and the goods that I've delivered upon them. I'll, my lords, quickly take your lordship through few of these documents that are there. First, my lord, your lordship will kindly have the invoices. This, your lordship will find, my lord, from pages 8 to 225. These, my lords, are 81 invoices. Page 8 to 225, this of my judge's brief of document, my lord.
Wait, judge's brief?
There are 2 volumes of the judge's brief, my lord.
Okay. Yes.
Yes, my lord. My lord, this, my lord, is Exhibit D.
8 to 22.
8 to 225, my lords. So these documents, my lords, I'll just, if your lordship will allow me to place page 8 once, and then subsequently the pattern follows.
Yes.
Page 8, your lordship will find this is an invoice raised by the plaintiff, Jal Nidhi Bitumen Specialties Private Limited. Left-hand side, way bill number, invoice number, reference number is given. This is the first bill dated 3rd July 2019, my lords. The particulars of the supplied goods are there for a sum of 161,896. Now, your lordship will kindly have at the bottom of the page the terms. Payment terms, your lordship will find. Payment not made within 15 days, then interest at the rate of 18% per annum.
Yes.
So this is reflected in the invoice. Now, if your lordship kindly, my lords, turns the pages, the page at page 9, your lordship will find the e-way bill. The e-way bill, my lord, is issued in order to facilitate transfer of goods from one place to another with the government portal. So the way bills that I have issued, which testify to the fact that I have delivered these goods, my lord, upon them. Similarly, this continues, my lord. So page 8.
Every invoice is containing the e-way
bills, my lord. And also, my lord, there are a few credit notes that are there. The credit notes were issued upon the defendant by the plaintiff because the defendant wanted some concession on for rate. So that to that effect, we've accommodated them as well. Irrespective of raising of these credit notes, no payment has come along of the entire invoice. Only a sum of rupees 15 lakhs has come. Now, my lords, another testament of the fact that the goods that I have supplied upon him was of satisfactory quality. For this, your lordship will kindly have, my lords, page 4 of the judge's brief of document. This is Exhibit C, my lord.
8 to 25, no? 8 to 25 or
8 to 8 to, my lords, 225. Absolutely, my lord. Your lordship is
225.
Yes, my lord. Exhibit D, my lord.
Okay.
Now I am placing before your lordship Exhibit C, my lord.
Yes.
This your lordship will have at page 4, volume 1 of the judge's brief.
That is at the 8 to 25 exhibit. What is the exhibit?
Exhibit D, my lord.
D?
Yes, the first one that I was placing before your lordship, the invoices along with the...
Is?
Page 4, my lord, is a test report that has been issued by Omega Consultant Services. So your lordship knows, my lords, that once government tenders are issued, usually you have to undergo the process of testing the materials that you are placing.
Yes.
So accordingly, the defendant did that. At the instance of the defendant, this test was carried out.
Yes.
Issued to Harpal Singh, your lordship will find at page 4, my lord.
Correct.
This dated 14th March 2020. And this is the goods that I have supplied upon him, which he is using.
And this is exhibit?
This, my lord, is exhibit C, my lord. Remarks your lordship will find at page 4. Above bitumen modified bitumen emulsion for microsurfacing sample was duly tested as per relevant specifications and found satisfactory with respect to above test parameters.
Yes.
So, my lords, this fortifies my claim that the goods, although supplied to him, no contemporaneous objection or any objection to that effect with respect to the quality thereof.
Next, then.
Now, my lords, for the purpose of acknowledgement of the liability by the plaintiff, your lordship, my lords, will kindly have first the bank statement, my lords. This, my lord, your lordship will find at page 229 of the judge's brief, my lord. Volume 2.
229.
Yes, my lord. This is exhibit F, my lord. $229, your lordship will find.
Yes.
This is issued by ICICI Bank for, my lord, the period of 1st March 2021 up to 31st March 2021. It starts at 229, your lordship will have 230, my lords.
31st of March till date. So till date is what is the date of this letter?
This, my lords, your lordship is 2nd April 21. The generation date, your lordship will find at page 230, my lord.
230?
Yes, my lord.
Achha, this one.
Yes, my lord. My lords, if your lordship kindly has page 231, this is the bank statement that has been maintained by the plaintiff company.
Yeah.
231, my lords, fourth transaction from the bottom, your lordship will have. This
30th March.
transaction dated 10th March 21.
Yes.
I have received a sum of rupees 15 lakh, my lord. Your lordship will have Harpal Singh and then the details of the transaction. That
30 March 2021.
30th March 2021.
RTGS.
Yes, my lord.
15 lakhs.
Yes, my lord.
15
15 lakh.
This is page 2. This is also exhibit F.
This, my lord, is exhibit. I'll tell your lordship. Exhibit F, my lord. Your lordship.
The continuation of the certificate.
Correct, my lord. It's
Paid
exhibit.
rupees 15 lakh.
Yes, my lord.
Yes. Then.
So this, my lord, is an admission. In further admission of its outstanding dues, your lordship will kindly have page 232, my lords, of the judge's brief. This, my lord, is exhibit G. This, my lord, is a signature. Your lordship will have, this is a ledger that has been maintained for the defendant by the plaintiff, wherein your lordship will find the transactions up to 31st March 2020.
It's a ledger.
Yeah, it's a ledger and there is an endorsement, my lords. This endorsement is dated 25th March 2021, my lord. This is at the instance of the defendant.
So balance is 19 lakh 25,000.
This, my lords, was as on 31st March 2020.
Closing balance is 19 lakh 25,211.
19 lakh 25,000.
As on 31st of March 2020.
Correct, my lord.
Correct.
Yes, this is only with respect to sales that I have made. Between the period of 1st April.
The signature is of defendant.
Yes, my lord. Harpal Singh.
Then.
So, my lord, these are two unequivocal, absolute, unqualified admissions by the defendant with respect to the outstanding dues that accrue against the invoices that have been raised by the plaintiff from time to time. Lords, altogether 81 invoices have been raised by the plaintiff between the period of 3rd July 2019 up to June 11th, 2021, my lords. Your lordship will kindly have page 11 of the plaint once. I have very briefly enumerated in a tabular format.
And what is that page 233?
233, my lords. 233 is a ledger that I have maintained. I have purposely not taken your lordship through that because I have already placed the bank statement before your lordship, my lord.
If you're
So-
telling that this is not, it is you're maintaining.
Here, I'm sorry. So I'm sorry, your lordship is very correctly indicated. 233 is a continuation, my lords. Your lordship will have
If you say the signature in
signature and
232
then the same
is
here
yours,
in 25th March 21, my lords. I'm sorry. Yes, my lord.
So page 233 is 20 till 25th of March.
Till 25th March
This is
21.
also the same exhibit F.
This, my lord, forms a part of Exhibit F, my lords. So the earlier one was only up till March 2020, and then, like your lordship have rightly indicated, my lords, 25th March 21, the balance. That is the set.
So here it is 1 crore 9,63,000.
Yes, my lord. And my lords, the goods have been supplied thereafter as well, up to June 11th, 21.
Okay.
So that's why your lordship will find that there'll be a difference in figures.
Okay. So this is the one. Then
Yes, my lord. Then, my lords, I was just placing page 11 of the plaint once, my lord, if your lordship will have.
yes.
This, my lord, has a tabular representation of all the invoices
These are
that
the
have.
details of the invoices.
Yes, my lord.
How many invoices?
Altogether, my lords, 81 invoices have been raised for a
81.
principal sum of rupees 1 crore 53 lakh 94,743, my lord.
Where will get the total? 1 crore. Where will get the total?
My lord, your lordship
Not
will
get
have.
the total here.
Yes, I have not given the total here, lordship, right?
Where you mentioned that it is at 1 crore 15 lakh.
My lords, in that event, your lordship, my lord, will kindly have the compilation that I have made. Here, your lordship will have page 237, my lord,
Just a minute.
of the judge's brief of document. This is a computation of the outstanding dues as on 31st March 24, which inter alia also contains the part payments that have been made. That is, those have been adjusted. Lordship will have page.
1 crore 53 lakhs.
I'm sorry, my lord.
What is the total?
1 crore 5394, my lord.
That is the paragraph 20.
Correct, my lord.
Paragraph 20 which you made the claim.
Para 20 at page 20 of my plaint, that is there, my
That is
lord.
the claim.
Yes, my lord. In any event, from the document also, I can place it before your lordship, my
Where is
lord.
the document?
Your lordship will kindly have page 237, judge's brief of document, volume 2, my lords.
Just a minute.
Your lordship perhaps will have a better understanding from this document. It's a computation sheet, my lord.
Where?
Page 237, your lordship will have judge's brief, volume 2, my lord.
237.
Yes, my lord.
Yes. Yes.
This, my lord, is exhibit I, my lord.
Hmm.
Your lordship will have, this has been prepared by the plaintiff company
Hmm.
towards the accounts of the defendant for the period of 1st July 2019 to 22nd December 2023, my lords.
3rd July.
Yes, my lord. Now your lordship will have the details of all the sales that have been made from
3rd
time
July
to time.
till
This is up till 22nd December 23, my lord.
no. Page 237. So
Page 237, my lord.
page 237 starts from 3rd July 19.
Yes, my lords.
Correct.
3rd July 19 is the first sales that I have made to them. I've
First,
raised my
then
invoice.
it continue.
Then it continues.
Then it continue. Next
February
page
2020.
238.
Yes, all the way. Your lordship will find up to
38.
11th June 2021.
11 June 2021.
Yes, my lords. So that is the last invoice that I've raised upon.
That is the 11 June 2021. 11 June
Yes,
2021.
11 June 21. That's the last invoice I've raised upon them.
Yes.
Yes, sir. At page 237, your lordship will also find that I have adjusted a sum of rupees 15 lakh that I have received against the in terms of FIFO, my lords, first in, first out. So the bills that were raised chronologically top in line have been adjusted first to against these 15
So
lakhs.
after the adjustment, 1 crore 53.
1 crore 53, my
That
lords.
is after adjustment, or it is the
No,
total.
my lords, not. So your lordship will have 153 is the principal amount that is there, my lords.
So
After adjustment, it comes down to 138.94 740.
then how you are claiming? Kindly come to the page 20 of your
Yes, my
paragraph
lord.
20 of your print.
Yes, my lord. Your Lordship will kindly have para 20 of my plaint, my Lord. Particulars I've given 153.94. Then, my Lord, I've adjusted a sum of 15 lakhs.
15 lakh
Yes, my Lord. And similarly, I've done that here against the principal as well, my Lord.
153.94.
743.
743 minus
15 lakhs.
15 lakhs.
Yes.
Yes, then.
And then I've added interest to come
That,
to a,
that is
yes, my Lord, 220. So that
interest from which date you are asking for?
interest, my lords, I am asking from the time because these, your lordship knows, are running accounts, my lords, continuous and open. So I am asking for interest, my lords, 15 days from the date on.
That's correct.
Yes.
15 days from date.
Yes.
So your invoices are different date. The last invoice is of
11 June 29.
2021.
Yes, 2021.
2021.
Correct.
When you made the demand notice.
Yes, my lords. Now your lordship kindly has the demand notice. This is dated 2nd July 2022. My first demand notice. I have enumerated this in my pleading at para 16, page 18 of the plaint, my lord. 2nd July 2022, my lord.
Yes, 2nd July 2020. That is page.
Page 235, your lordship will have of the judge's brief.
That what is annexer?
This is Exhibit H, my lord. Altogether, my lords, 2 demand notices given. First on 2nd July 22 and the other one on 23rd December 2023, my lord.
How, from which date the interest is to be calculated?
Yes, my lords. Now,
Because in paragraph 20 only you ask for the 18%. You are not given the date.
yes, my lords, that's what. If your lordship will have the reliefs at page 24, what I have done is that I have sought for reliefs up till 31st March 2024, whatever was accruing that I've done.
From which date?
So in that event, my lord, your lordship will, what your lordship, subject to your lordship's, whatever pleases your lordship, my lord, on the amount of 2 crore 20 lakhs, my lords, if your lordship then accrues interest on and from 1st April 2024, my lords.
Okay, we'll see.
That your lordship. My lords, that apart I have placed the 12A is there, my lords. This is the sum and substance of the matter, my lords.
Okay.
If your lordship wants, I can file a 2-page note, if at all.
Hearing concluded, CM.
And just one last thing on limitation, if your lordship wants. But this is the order of suspension, suo motu order of suspension passed by the Supreme Court suspending limitation from 15th March 2020 till 28th February 2020.
Last was 11 July, no?
Last bill was 11th
11
June
June
2021. If your lordship has 3 years from there.
2024.
Oh, I have filed this, my lord, on 10th April 24. I was for abundant caution taking it from the first invoice. So in that event, I have the recourse to the
So last bill, the supply is the 11 June 2021.
11 June 21.
And you file April 2024.
I have filed it in April 24.
So it was when a suit has admitted by this court only. September.
This, my lord, has been filed on 10th April 24.
No, it was presented on May.
Yes.
That is also.
So still we are within limit.
Okay.
For abundant caution, I have just handed over. I'm so grateful for a patient hearing, my lord.
Yes. Item number 6.
I appear on behalf of the Bank of Baroda. I appear on behalf of the Baroda, Bank of Baroda.
Baroda. Who is for the plaintiff? What is the application? You got the application? Suit was dismissed. File an application for restoration. Again, nobody is appearing. Who has filed this? Rani Ghua. WS may be accepted. Who's WS? My Bank of Baroda. You are aware what application is this? Record or not? None appears on behalf of the plaintiff. Sense suffering for the defendant. Plaintiff has filed the present application being GA Com 2 of 2024. Praying for recalling of the order passed by this 2 of 2025. The plaintiff has filed the present application being GA 2 of 2025, praying for recalling of the order dated 25th of November 2024, wherein this court has dismissed CS Com 489 of 2024 within bracket old CS 67 of 2024 for default. Full stop. When the matter is called, none appears on behalf of the plaintiff. No accommodation is sought for. Accordingly, GA Com 2 of 2025 is dismissed for default. Next.
Lordship, I am for the defendant in this matter.
Yes.
We had filed an application for extension of time to file a written statement. On the last occasion, Lordship had directed us to come with the written statement. It is ready, it is affirmed.
When you received the writ of summons?
On 26th of March.
26th of March. When you file the written statement?
In my application, it's on page. It is on paragraph 3.
Correct. Your written statement is ready.
It is ready. It is ready and
affirmed. And it is affirmed.
Affirmed today, 22nd
Today.
of. The last date is
26th of March.
Last date is 24th of July. If we count the 120 days, that
24th of July. You're sure?
24th of July.
You're sure?
Lordship.
Okay. The none appears on behalf of the plaintiff. Defendant has filed the present application being GA Com 2 of 2025, praying for extension of time to file written statement. Counsel for the plaintiff submitted and defendant submitted. The defendant has only sole defendant.
Sole defendant.
Defendant has received the writ of summons on 26th of March 2025. But the defendant could not file the written statement within 30 days from the date of service of the writ of summons. She submits that the defendant entered appearance on 15th of May 2025 through the advocate on record. Full stop. And then a counsel for the defendant submits that after receipt of the writ of summons, the defendant was out of station to attend the marriage of the relatives, and when he has returned, the 30 days was over. Subsequently, the defendant has contacted the learner advocate, and the learner advocate, and as per the advice of the learner advocate, the defendant has provided all the information to the learner advocate for the defendant, and accordingly, the learner advocate has prepared the written statement. Counsel for the defendant submitted the written statement is ready and also affirmed on this day, that is on 22nd of July 2025. Learner counsel for the defendant submitted that though the defendant could not file the written statement within a period of 30 days, but has affirmed the written statement and the written statement is ready within the outer period of 120 days, and she prays for acceptance of written statement. At the learned counsel for the defendant peruse the materials on record and the cost shown in the application. This could find that the defendant has shown sufficient cause for not filing a written statement within 30 days. This could also find that the defendant has affirmed the written statement on 22nd of July 2025, that is within the outer period of 120 days. Accordingly, the written statement is the department is directed to accept the written statement subject to scrutiny by the department. Subject to payment, how much payment? Payment of rupees 1,000 to the State Legal Service Authority within a week from date. The payment of cost, the proof of payment of cost to be shown to this court on the next weeks. The defendant is directed to file this written statement in the department by tomorrow.
Also, I'll serve the plaintiff by letter of intimation.
Already served.
I will.
The defendant is also directed to serve the copy of the written statement to the plaintiff by tomorrow. GS so disposed of. ये उनको दे दो, फाइल कर देंगे वहाँ. इसमें एक काम करो, ऑर्डर नहीं होगा उसमें लिख दो, written statement is accepted subject to scrutiny. Granted leave to file in the department. Written statement is accepted subject to scrutiny by the department. The dependent director to file the written statement by tomorrow in the department.
8 matter for the petitioner. But this matter was served previously also. I have filed an affidavit of service. On the last occasion also, I had prayed that I will serve again to the defendant. This is my service. And again, the door was locked, intimation served, and it has returned back as unclaimed.
What? GA?
Yes, the Chapter 13A application.
Chapter 13A application.
But the summons was served upon the defendant on 16th May 2025, my lord. 120 days is ending on 17th August 2025. Today we are on 67th day.
Come after that.
Then the matter can be set ex parte.
That's come after that, then I will.
So far as this application is concerned, is not related to 120 days. It is my application.
That's correct. However, but if the writ of summons is under Chapter 13.
We have already served the GA. Writ of summons has been served independently.
That is correct. But unless the
Very well.
time is, that is correct. No, but the writ of summons notice is.
I will kindly fix on 17th August then, because that is the 121st date.
17 is Sunday. I am fixing on 18th.
18th. Deeply.
Counsel for the plaintiff submit that the plaintiff tried to serve the notice of the application big GA-Com 1 of 2024 by speed post, but the same was written with the endorsement. Door closed. Let the same be kept with the record. Let the matter appear on 18th of August 2020.
But we have served on email also, my lord.
Next.
Matter number 9, my lord, I am for the plaintiff, my lord. The defendant had filed an application, my lord, seeking for extension of time to file written statement, my lord. That GA2 of 2024, my lord.
You are for the
Plaintiff, my lord.
Where is the defendant?
He was there, my lord. I don't know where he is now.
Defendant is not here. Whether they have filed the written statement?
By leave of the court, they have filed.
Within 120
I have
days?
heard that. Yes, my
कोई
lord.
report आया है क्या?
The GA2 they have filed.
July 24. Effect report. ना report आता. It has been described. No, there is not report. Where is the defendant?
Let it be not.
Not today. Come tomorrow, we'll see. Not today. Next.
I'm appearing for the plaintiff petitioner. My lord, GA1 was my application, by virtue of which, my lord, your lordships was pleased to, my lord, grant an order of injunction in August 2024. Several time, my lord, the interim order was extended. The last extension was on June 18, 2025. It is expiring today, my lord. I was praying for, my lord, extension.
Is with the double barrel ban.
Your Lordship, I have.
The objection to not to extend the interim order.
This is the first time they are appearing in this
Yes, Your
matter.
Lordship. We've been briefed yesterday, Your Lordship. I'm praying for 1 week's time to take instruction, and Your Lordship will extend the interim order for that 1 week, Your Lordship.
And so far as, my lord, GA3 is concerned, my lord, that was disposed of already. It was for amendment of the plaint. That application, my lord, was disposed of by an order dated 17th of April 2025. It's wrongly, perhaps wrongly appearing in the list, my lord.
GA3 got ho?
GA3.
GA1?
Your Lordship, I was also praying if a copy of GA1 may be served upon
We'll
us,
serve them, my
Your
lord, immediately.
So. You have not received the GA1? Counsel for the defendant press for time to file affidavit in opposition.
Yes.
In connection with GA1 of 2024. That affidavit in opposition we filed within 2 weeks. 3 weeks.
3 weeks, Your Lordship.
Within 3 weeks. Reply, if any, there to be filed within a week thereafter. The counsel for the plaintiff submit that. Press for extension of interim order. In view of the above, in view of the submission made by the counsel for the respective parties, the interim order is extended till 21st of August 2025. Let the matter appear, or until further order whichever is earlier, let the matter appear on 21st of August.
21st
August.
I'm grateful.
Next.
Lord, I appear for the plaintiff, my lord. GA3, my lord, is my application for payment of occupational charges, my lord. On the last occasion,
I am for the defendant, my lord. J2 is my application, my lord. My lord, it's my application, my lord. When the original plaint was served upon me, my lord, mistakenly, my lord, page 22 was not served upon me, my lord. I made an prayer before them to serve me the copy, but that was served late, my lord. That at that time, my lord, I have already filed my written statement, my lord. But this is my application only, my lord, to file an additional written statement with regard that the allegation made in those paragraph 52, that was only the paragraph that was not served upon me, so that I can deny the allegation those made therein. That is my application in GA2, my lord. And my lord, so far as GA3 is concerned, my lord, it is for their application, and I want to file an opposition.
What is the
in this regard.
application?
my lord, GA2, as far as GA2 is concerned, my lord, I do not have any objection, my lord, that can be allowed. As far as GA3 is concerned, my lord, it is a application for payment of occupational charges and also rent, which they are not paying. It's a suit for eviction, my lord, commercial suit for eviction. Rent admittedly has not been paid on and from September 2020. They have in the written statement come forward and agreed to the fact that they have tried to tender some rent. We did not accept. We are entitled to payment of rent, and they also want to make payments of rent. My lord, that rents have not been paid till date. As far as
I want to file an objection, my lord.
Yeah,
Opposition.
admitting what?
My lord, only one little some aberrations are there, my lord. Yes. A little one. 2 weeks time, my lord, to file my
my lord, in the meantime, if the admitted amount, if your lordship, my lord, that is.
If your lordship can grant me 2 weeks time, my lord, thereafter your lordship decides, my lord. And my lord, this additional written statement, my lord, it is, my lord, I have stamp punched on the day, my lord, I filed this application, but it is not affirmed, my lord.
Dependent has filed an application being GA-Com2 of 2025, praying for filing additional written statement only to the effect for dealing with paragraphs.
Paragraph 52, paragraph 51 and 52, my lord,
Paragraph
of the plaint.
51 and 52 of the plaint. They submit that the plaintiff has received the writ of summons along with the copy of the plaint. Defendant has received the writ of summons along with the copy of the plaint, but in the plaint, the page number
22, my lord.
22 was not available. which carry the paragraph 51 and 52.
51 and 52.
51 and 52. 52, and as such, while filing the written statement, the defendant could not deal with the statement made in paragraph 51 and 52. Subsequently, on request of the plaintiff, defendant, the plaintiff has served the page number
22.
22, and accordingly, the defendant has prepared has affirmed the additional written statement dealing with paragraph 51 and 52. Full stop. Consider for the plaintiff is no objection, submit that. If the additional written statement is accepted, has no objection for acceptance of the additional written statement only with regard to the contentions made in paragraph 51 and 52 of the plaintiff. In view of the with regard to the contention made in paragraph 51 and 52. In view of the above, the defendant is granted leave to file additional written statement dealing with paragraph 51 and 52 of the plaint within a period of 1 week after serving the copy to the learned counsel for the plaintiff. In view of the above, GA Com 2 of 2025 is disposed of. The plaintiff has filed an application being GA 3 of 2025, praying for a direction upon the defendant for payment of admitted rent of the admitted rent
and occupational
charges. The counsel for the defendant prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, that will be filed within a week thereafter. Please the matter on 21st of August for hearing of GA 3 of 2025.
But on instructions, may I pray for fixing of a time lot today? Affidavits, if completed, on the next day we cannot.
Then it will go.
But any time, September also would do, Lord, not something.
You take instruction. If you are admitted, you take
Yes, my lord, kindly seize page 16.
But I have taken instruction. My instructions are to file opposition.
Okay, file, but you take
Yes,
instruction.
well, that I will.
Lord, page 16, if your lordship sees one. Lord, kindly fix a date, Lord,
Yeah.
if possible.
11:30. 11:30. 11:30.
Deeply obliged. 21st.
Next.
Well, I am for this respondent.
Well, I am carrying
Respondent.
affidavit in reply.
Lordship, I appear for defendant number 2, your lordship.
You have to die.
Affidavit in reply for the
Same thing for Malad seeking Malad reply Malad against our opposition Malad in opposition on the last week.
I am
Last week,
starting
Malad.
with the respondent number 1 here.
You are appearing for?
Petitioner?
Yes, you are appearing for defendant number 1.
Yes.
Yes, Malad. Union of India.
So what you
Railway.
have
One.
What
I
you
have
have,
already I have already filed Malad opposition Malad.
you have filed the
Reply not filed.
reply filed. So it
Well, keep it any day, Millard, and extend the interim order, Millard, which is expiring Millard
no.
day after tomorrow.
No, Malad. You have to kindly fix the date for Malad final proceeding because Malad interim order enjoying for the long period Malad.
And when you have entered appearance?
Your lordship, may defendant number 2 be also be served a copy.
For what? It's between plaintiff and you run the law, then pay for before the court.
Lordship would kindly allow grant me leave to file my written statement, your lordship.
When you receive the copy,
Lordship, we received the on 9th of April, your lordship, but we were informed by the bank on 22nd of May, your lordship.
Okay, 9th of April, the write up someone when the write up
9th of April, 9th of April, your lordship.
Sure.
Yes, your lordship.
So you liberty.
We are within 90 days, your lordship.
No, no. When
Written
it
statement
is,
is ready.
Dasgupta, when it is served.
Millard, I have to take instructions. Millard, nobody is there with me. Millard, yes. Millard, I'll take instructions on this.
Your
Millard.
lordship complied within the 90 days period, your lordship.
Let it, Millard, hold his horses for today. I'll
No,
take instructions.
take it. Leave is granted to the defendant.
Millard, I'll have to check, Millard.
No, I am not accepting.
Very well.
Leave is granted to the defendant number 2 to submit the written statement in the department subject to acceptance.
Grateful, your lordship. Great.
You have to kindly take it up short date Malad.
By tomorrow.
Grateful, your lordship.
But Millard, I have not checked, Millard.
That's why I am not accepted subject to acceptance. If it is after 120 days, automatically.
I'll
If
check.
it is
Within 90
days, then he has to.
I'll let your lordship know by the next.
Within 90 days, your lordship.
কি বলছে? The plaintiff has filed affidavit in reply to the
Copy has not served, my lord. Copy may be served, my lord.
Served.
Copy, sir.
Let it be accepted first. You're not served.
No, man, I should get a copy.
Affidavit reply.
No, the written statement.
Reply no has not served, my lord.
Accepted.
Written statement will shall serve on the next date, Your Lordship.
Affidavit reply to in connection with GA Comp 1 of 2024. Let the same be kept with the record. Counsel for the plaintiff press for extension of interim order. Interim order कोई एक डेट है कोई बात में देखो. सितंबर में देखो कोई डेट है.
বাচ্চাগুলোর কি আছে?
Maybe first week of September.
Yes, on
Because puja occasion is very near September last week, third week of September.
25 or until further order whichever is allowed. Release the matter on 1st September 2025 at 3 p.m.
Yes, my lord. Correct. Deeply obliged.
for hearing
The
of
interim order, my lord, are extended.
1st September.
And my lord,
Deeply
first
obliged.
my lord is fixing, and my lord, 1st September is the.
Yes, my lord. That's a final hearing. Yes, my lord.
Yes, I
That
think
can be, my lord. Yes, my lord.
Interim
Deeply obliged.
in the list, item 23.
which for the other side. Record an order.
23. Commercial.
So the matter is listed at item number 23 in the today's list, but due to positive time, matter could not be taken up for hearing. According counsel for the plaintiff press for an extension of interim order. In view of the above, the interim order is extended till 20 August 2025 or until further order, whichever is earlier. Let the matter remain in the list.
Deeply obliged.
Fighting today, my content is appearing for the
As an order for furnishing security. So what you want? Vacation. Item number 16. The matter is appearing in the list at item number 16. Counsel for the plaintiff press for extension of interim order. There is a direction for affidavit.
No, my lord.
You will file.
Full
stop. Counsel for the defendant press for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks, 3 weeks. Within 3 weeks, reply if any there to be filed within a week thereafter. This is the matter on 21st of August 2025. Interim order is extended till 21st of August 2025 or until further order, whichever is earlier.
Lord, commercial list item 54 and 55. Lord, no interim extension. I'm for the defendant. Lord, all my bank accounts are blocked. I urgently, my lord, need to make some payments. Your lordship, but fix the matter today. My lord, kindly, my lord, keep it tomorrow, my lord, slightly, my lord, high on board so that, my lord, the matter will be.
Hearing.
My lord, because, my lord,
who is for the other side?
I'm offering an alternative security.
What?
My lord, there's a plot.
That is also that is also mortgage.
No, not mortgage. That is not mortgage.
Not mortgage.
I will secure, my lord, the debt and I'll fight the suit. But
Which
my
for
lord,
the other side?
who,
Item number?
My lord, 54, 55. My lord, I'm not seeking any reliefs today. Kindly just keep it tomorrow, my lord, high on board.
54, 55.
Yes, if required, my lord, I'll personally
54,
telephone.
55 undefended suit.
My lord, there was a confusion.
Suit is undefended.
Suit is undefended. We filed an application, my lord, for it to be transferred to, my lord, being a non-commercial suit because it's not a commercial suit.
Okay.
Oral loan contract, my lord, your lordship's judgments are there. Once that happens, we can file a written statement.
54, 55 ना कल क्या आएगा? New motion. Day after tomorrow, new motion. It will be up.
I'm so grateful.
New motion में इसको ऊपर कर दो.
No, don't be unreasonable.
Undefend new motion कर दो. Undefend में रहने दो. अच्छा वो नहीं आएगा ना. उसको एक काम नहीं फिर वो ठीक नहीं है. ठीक है न्यू मोशन में कर दो जीए करके. ये कर दो.
So grateful.